Make a mention before court number 13. No, it's okay. You may make a mention before court number 13 or before registry. It will come before this court only. Item. Not received. They did not receive. Sure. Yes, when it can be. It did. One did. 18th of May, so and so. Interim be continued till next day. Yes. Twenty, 24 and 25 are connected. Yes, in 20, 24 and 25. Same order. Interim be continued. Yes, when it can be. 19. Yes, 29. What is the position? He is in Kohima. Still when it can be retained. Next week. What? 6th of May. Interim be continued. Linked with CDB retained. What is the position of 31? Are you on interim? Or how many petitions are there? Two. Interim is against. She did not receive. It's very important. Yes, when it can be.
6, 7 or 8.
On 25, 26.
Let's see, there is no interim against petitioner number
205, man.
20.
20.
2005. And
Interim
it will be
asan?
continued till next interim. Actually,
18th.
formula. Interim be continued for petition number 1. Petitioner number 1. Till next date. Petitioner number 1 till next 2005. CDB issue. Yes.
He wants to fix it on 14.
There is no interim for respondent petitioner number 2, your lordship.
When?
On 12 or 13, at least, your
12.
lordship.
Can it be?
12 maybe.
Obliged.
Please no 12
Obliged.
May I please, your lordship? May I please, your lordship? Lordship, with the consent of other side, I beg to mention supplementary item 47 and 48, lordship. Actually, on last occasion, it was when discussion was made, it was fixed on 29, but wrongly it was listed on 27 today. So the actually, advocate has some difficulty, lordship. So maybe
in both the matters you are for?
petitioner.
In both the items?
Yes.
You are for the petition?
Yes, lordship.
In 47, Mr. D. Burman is there. And in 48, and Ahmed, these are the. Have you taken consent?
We had taken consent. Senior advocate, my engaged counsel informed me he has already informed the other side.
Make it confirm because otherwise it was fixed on 29.
Yes, lordship.
You are MS?
MDUS.
In item number 48, your name is not reflected. In item
behalf
number
of
47, MDUS is there.
I am on behalf of DK Nat.
DK Nat.
Yes, lordship.
Because two separate sets of counsels are there in 47 and 48 for the respondents. Don't know whom we have informed. So very, very clear. with the consent of the third MS MDAS, the learned counsel appearing on behalf of Mr. T. Hilt. And with the consent of the other side, when I do that, and this counsel is not prepared to argue with the case.
That's an interim order passed on interim.
In both the matters,
Yes, Lord.
interim order be continued till next set of listing list when it can.
If possible, 29. If possible, 29, Lord.
No, please. 4th of May.
Obliged.
Obliged, Lordship. Lordship, I have to mention a AV for withdrawal, Lordship. Maybe come up
Make a
on-
mention before court number 13 or before East.
Wait, please, my lord. I beg to mention item number 30, my lord.
Yes, what is the position of 30?
Case diary not received, my lord.
Are you on interim?
Yes, my lord.
CD not received. Interim be continued till next set of listing. Yes, what for when?
On 21/5, my lord.
Deeply obliged.
I believe so much. Lordship, I beg to mention item number 34 and 35, Lordship. CD not received, Lordship.
34, 35, my lord, charge sheet submitted. দুইটা একই নয় জানো dispute.
Out of same police.
Same police station, my lord.
Yes, are you on interim? No,
Yes, Lordship.
you are
Okay.
interim. Okay, be extending your interim up to 15 days. And within 15 days, you appear before the learned trial court bureau with an appropriate application for pay
Yes.
regular day. Because you are already on interim, that will be extended. Yes, what is the CS number?
CS number, my lord, 123/26, dated 31/3/26.
I said, CS 123, 31, 15 days of extended with for the matters. Okay,
Lordship, with the consent of the other side, I beg to mention item number 49 of the supplementary list, Lordship.
item number?
49 of the supplementary list. Lordship, here the respondent has filed an affidavit in opposition, so kindly 2 weeks' time may be granted.
You are for the petitioner.
Yes, sir.
Other side is present here. No?
Yes.
My lord, I am appearing for the respondent.
You have already filed your affidavit.
We have filed our.
You are Mr.
Take a step.
A. Kashyap.
Take a step.
Part Mr. A. Kashyap appeared for the petition and also part you are Mr.
R. Das.
Part Mr. Ardas, you done it something again. It's submitted
My lord,
by
may I pray for a date, my lord?
Yes,
18th, may I
submitted
pray
that-
for the 18th?
Submitted by Mr. Kashyap that they needs at least 2 week time to file their written reply against the in opposition filed by respondents. There. Yes, after 2 weeks,
18.
18th,
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 1/8.
Omelette.
obliged.
18th file and applying the petitioner side to file their written affidavit in reply.
May I please, Your Lordship, I beg to mention item number 41, Your Lordship. I am for the respondent. I have taken consent, Your Lordship.
You are for the respondent.
Respondent, Your Lordship.
You have taken consent of the
Consent, Your Lordship.
Mr. S. A. Hussain did done it with the consent of the paid for an item. There, legitimate accordingly. After 2 weeks, we'll do.
2 weeks, Your Lordship.
We are not fixing any date here.
Lordship.
After 2 weeks, as an edit, we will get it. But just tell us, is there any interim is operating?
Lordship, no, as per my instruction.
Can I get that? 41. Then after 2 weeks, as an edit, we will get it. Yes.
May I please, your lordship, with consent of the other side, I beg to mention item number 13 for adjournment today, and we are on interim, your lordship.
30.
13, 1-3.
You are for the
Petitioner,
petitioner. You are MS,
Anil Lashkar.
RMS and A Lashkar. And with the consent of the IC, paper nature. Clear it out, list matter accordingly. We're not fixing any date. After 2 weeks, it will come.
Much of that,
After
your
2
lordship.
weeks, it will be.
Ma'am, your lordship, we are on interim order.
Interim was there. Interim be continued.
Much of.
I was back to mention item 12, my lord.
12.
We need some time, my lord. 12, criminal petition, my lord, case diary otherwise received, my lord. CD received.
What we are going to do?
I will have to return back the CD, my lord. Otherwise, already stayed, my lord. Interim order is there, my
Already stay.
Stay, interim order is there.
Investigation is stay.
Investigation stay.
Then too you can return. Then too you can retain, or otherwise you can retain.
Yes, I can retain it, my lord.
You can retain.
Yes.
You are Mr.
AK Sahiwala.
Mr. A.K. Sahabara, the director of the petition. And when I joined, some personal is not in a political firm. It's submitted by Mr. Bott. It done an additional B seat has already been seat. Stop. CDB retained till next date of listing, listing matter according. 11.
My lord, can it be on 18th of June, my lord? 18th of June?
18th of June.
No. Then before that. 28th of May?
20.
28. No, my lord, on the 13th of May. May 13th or 12th? 13th May. 13th May. Interim order to continue.
Interim be continued.
Great.
Lordship, I beg to mention item number 10. We have taken consent from the other side. I am appearing on behalf of Counsel A. Goel. He's currently out of station today. He's in Kohima. So your lordship may fix another date for this.
Have you informed the other side?
Yes, we have taken consent.
With consent of the other side, and counsel appearing on behalf of Mr. A. Goel for the petition paid for an adjournment. And listing matter accordingly after 2 weeks as on a date fixed by the date. Is any interim is operating here?
Not as per my instructions, Your Lordship.
So we are listing it after 2 weeks
Much obliged, Your Lordship.
as on a date.
Lordship, I beg to mention item number 37, Lordship. In this case, fresh steps was taken on and on 16/3, notice was issued. Then presumption may be taken that service is completed, because earlier also taken last year, Lordship. Nowadays, that
Then we have to peruse the record. It has to come.
Yes.
We have to peruse the record.
because Lordship, there is my election, Bar Council election is counting is going on. That is why, Lordship.
Then, Your Lord.
No, presumption করে দিলে হয়ে গেল, admission 1 মাস হয়ে গেল তো।
No, but on the last occasion, you were asked to take fresh steps.
We have taken steps. Notice was issued on 16/3, Lordship.
16/3.
Now, yes, now today, 7th. 1 month is already over. It is by registered post. A presumption may be taken that service is completed, Lordship.
How?
No, in the last address, in the FIR, in the name of informant, we have taken steps.
RMSMD, the learned counsel for the petition, but strictly what the learned additional people bring on. Next slide is submitted by MS state that they have taken steps on the respondent number 2 in pursuant to order dated 13/3/2026, and accordingly submitted that even after expiry of 1 month, as the registered, as the AD card is not yet returned, it may be deemed as proper service. In view of this, in view of this, the ST is hereby directed to track the to take the consignment report of the respondent number 2 and to place it before this next. Please do matter accordingly after 1 week will do. You are not
Yes,
fixing
Lordship.
any date.
Any date may be fixed on,
In that case, it will be after 3 weeks. 19th of May.
obliged.
In order.
Yeah, please. Item number 19, madam, on the daily list.
19.
19. CD notice, madam. In fact, my lordship has granted me interim order. I know.
I mean,
BA.
interim was there.
Yes, lordship.
CD not received, BA, my lord.
It is BA.
Lordship.
BA.
From my lord, Sheila Potter, please. Imagine.
CD not was issued in tender. Yes, bought up from Silapatra. It has
Silabuther on 14th of May.
14th of May. Interim be continued till next day.
Deep level. Yeah, please. Let's by instruction of the additional on to withdraw this.
All these items are the connected items.
Lordship. Out of my lord, same case.
These are all BA, na?
Lordship, B.
So they all surrendered it. They all surrendered it.
Yes, yes.
So we take it at order. Heard Mr. D. Gogoi did an petition. And also heard Mr. P. Bush did an petition. It is submitted to Mr. Gogoi that as per instructions, the petitions, you want to withdraw the cases. If you want to withdraw the case, and as the petitioner does not want to raise the bill application further. In view of this, the prayer allowed, let the petition be accordingly disposed of. No, let the petition is accordingly disposed of.
Plus deep level.
Lordship, bail application under 103 BNS. At this stage, we will call for people.
You are in custody since when? You are in custody since?
24/1/2026.
24,
1/2026.
24, 1.
At this stage, we are only seeking for TCI.
Yes, yes, I can understand. Case is not yet charge sheeted or is
It is charged, Lord.
charge sheeted?
Yes, Lord.
Oh, good.
Scan to
All for the scan copy of the TC along with the case diary. Distribute to the need. Yes, what it can be
Can it be on 7th of May?
7,
Ben?
I will
Or eight.
not possible.
8th of May?
11.
11th of. In
8th.
that.
11.
Eleven will do. 11.
I'm obliged, Lord.
May it please your lordship. 483 application, my lord.
The petitioner is behind the bar since 46 days, my lord, as on today, my lord.
46.
FIR is page 13. Page 13 is the FIR, my lord.
Yes.
May I read, my lord?
Hmm.
With due respect, I would like to inform that I, Sri M. Vishwanathan, site in charge of Silchaku area under KS Enterprise, situated at Ganeshguri, Guwahati, state that today at about 6:30 a.m. to 7 a.m., as I was in the site for inspection of the works in Silchaku near Ginger Hotel, some drivers of the site suddenly attacked me and brutally assaulted me with the intention to kill me with sharp weapons like with rod, bamboo stick, etc. on my head, which rendered me grievously injured. Further, the accused person also snatched my iPhone having phone number so and so so and so. The incident occurred while I was performing my duties as site in charge, supervision as art cutting and disposal of aggravated ox under contract agreement so and so for art cutting and disposal of aggravated Silchaku bill part so and so. After the incident, some of our drivers rescued me from the site and brought me to the Agile Hospital for immediate first aid treatment, and matter has been already informed to the Dispur police station by our company. And here in this present case, my lord, the petitioner, two petitioners is there, my lord. They rescued the informant and took him to the hospital, my lord. But in the FIR, their name is also mentioned. Therefore, they were arrested, and as on today, they are behind the bar since 46 days. At this stage, considering the length of detention, my lord, and the nature of offense, further detention may not be necessary.
Clear, page 14, my lord, the FIR named accused number, my lord, 5 and 10. My lord.
5 and 10 minutes.
They are specifically named by the complainant.
But in the FIR itself stated that some of the drivers took him to the
Yes.
hospital, but we do not know whether these are the drivers or some other persons took them
Yes.
took him to hospital. That is not known properly. But as per the FIR also, some of the drivers took him.
Named. Forwarding report is at page 15.
Page
15. Annexure. Two of the FIR named accused were granted bail, one of the by the trial court. One only. The trial
Session rejected.
But the trial court rejection order regarding the present petitioner not annexed in this.
Annexure. Annexure 3.
Which, trial court rejected. Rahul Rabha's one was clear. Rahul Rabha.
one you have submitted, most probably annexed. Other one you have not annexed.
My lord, we have submitted both, my lord. 17 to
For
22.
Ranjit, we have seen.
Rahul Rabha is page 17.
Page 17 is for Rahul Rava.
Page 17 is for Rahul.
Rahul Rava, my lord.
And page 20, Dhanjit
Page
Sharma.
20 for Tanjit Charania.
Rejected.
Mr. Ilu and the learning council for
Type of injury is not there in the earlier rejection order. Trial court rejected on 17/4. But type of injury is not there in the.
not. But Mr. You can't do the council for the petition also. But Mr. P. Water the learning petition keep appearing. It's an application under section 7. But it is submitted by Mr. Khan, the learning council for the petition that these are they are innocent and they have not committed any such offense as a resident here. Rather, these two are the persons who took the victim to the hospital immediately after the said offense. The further submitted that accused petitioners are in custody since last 46 days, and hence considering their length of detention also, they may be released on. Next, Mr. Botafoot, the learned additional people submitted in this report that their earlier bail application was rejected by the learned learned additional session judge prepared for case trial, and hence he insisted to call for case trial. Next, during the submission with by learned counsel purpose, I have also paid case trial, and the order passed by the learned court below. And it is seen that there is no mention about the type of injury sustained by the present petitioner, by the victim. So apart from that, it is seen that the accused petitioners are in custody since last 46 days, and hence the IO got sufficient opportunity to interrogate them, keeping them in custody, and hence further custodial interrogation may not be required for the purpose of investigation. In view of this, I find it effective to extend the privilege of bail to the present petitioner. It is a case of Kamrup Metro, I think. na?
Yes, Kamrup maximum.
To the satisfaction of CGM Kamrup Metro. Okay, thank you.
Deeply over.
May I please your lordship?
Yes.
483 application, my lord. My lord, there are two affairs. It is the family dispute land. We have been enjoying the land last 20 years, my lord. The informant has filed a civil suit at Kokrajhar Assistant Civil Judge, and my lord, and the prayed for recovery of the position. In the meantime, my lord, because as we have harvested the, we have cultivated the paddy, my lord, we went to the paddy field to harvest the paddy. In the meantime, the informant party, along with 14% opposed us, disturbed us, and attacked us. Then, also, there was a marpit from both sides. Both the sides, injured persons were admitted at the Kuchbihar Civil Hospital. Now, it was incident took place on 22/3/24/6, my lord. Now, both the parties have returned, my lord, at home. And, my lord, in the meantime, my lord, both two petitioners, father and son, 72 years old father, have been arrested by the police, my lord. But the other sides are still absconding, my lord. They are trying for anticipatory bail. I pray that 109 is that registered against both the parties, my lord. Yes. But my lord, injury is problem to my idea, my lord, as I was told, it is 324. Both the sides there are injuries, my lord. Actually, they have attacked us, my lord, while we have right. But I have annexed this civil suit also, annexed 4, page 36. Civil suit was filed by them.
Page 17, charge sheet is at page 16.
Charge sheet? No, charge sheet.
Charge sheet, please. No, I don't think.
15 number.
Sorry, ma'am.
Is it the charge sheet?
No, madam, sorry, I have taken.
Occurrence took place on 22/3. Charge sheet is not yet filed in any either of the cases. The other sides are absconding. So I pray them at least 72 years old father may be unleashed, and senior may be called for in both the cases, madam, with medical report, madam.
Yes, bottom.
Goshai Gaon, madam.
Yes, well. Otherwise,
It is admitted in the FIR. Land dispute is going on, and we have filed the civil suit.
although land dispute is going on, but here from the allegation in the FIR, madam, they
Marpit.
sustain serious head injury.
Yes, in both sides. Both sides.
You want to fall for case there?
Yes.
That's why I'm praying medical report may call for in both the 57, 58. Our case is 58, their case is 57.
When give a short date so that we can.
Yes. And one is my lord still under critical condition. My lord. Paste
No, no,
bill,
no. That is in 20, that
58.
is at 22-3. Both the parties have returned from Kuch Bihar, my lord. Alipurduar Hospital and Kuch Bihar Hospital.
But regarding the present case is my lord Gosaigaon PS case 58.
58, no, 57. 58 is their case. We have filed. We are paying for bail on 57. So that's why CD may be corporate in both the cases, madam, with medical report, madam.
They done an additional PP appearing on behalf. It is next one. It is submitted by Mr. Suman. There are two. There was a dispute between the two groups for land and between the parties. The one civil matter is also pending. Both the parties sustained injury, and there was a cross cases filed between them by them. And the present petitioners are in custody since 19/4/2026, and hence, considering their length of detention, they may be released. Next, but Mr. Bornapur, the learned additional people submitted in this regard from the FI itself, we see that the petitioners sustained, some of the victims sustained previous injury, and they are still in critical conditions. Considering all these aspects of the case, this court is of opinion that perusal of the CD along with the medical report will be necessary before passing any order on bail. In view of this, yes, let the CD be called for you.
On 21/5, my lord.
21-5, why? Well, 7th, there it has been called for anticipatory bail. It was fixed on 7/5 minute. So it will come on 7/5 minute. CD is coming on that day. There is another application for anticipatory bail.
On 11/5,
bail is pending in this
7/5.
7th.
7/5.
7th. What is the anticipatory bail number?
I'll
AB
give
number?
you. I'll give. Actually, it has been filed by different advocate, madam. That's why.
Whatever, if
Let it be on 7/5, I'll kill you.
Okay, 7.
My lord, regarding the 72 years old father,
No, it's okay. 7/5. We'll sit. Yes, okay, 7th.
Yes, 7.
Ma'am, please, Your Lordship.
Yes.
So this is a 482 application, Lordship, and in this case, Lordship, the FIR will file, Lordship, page number 9, Lordship. And in this case, Lordship, the FIR is filed in the year of 2014, Lordship.
Page
And,
number
the-
9.
Lordship, lost in the year of 2014, and charge sheet has been submitted, Lordship, in the year of 2022. After 8 years, Lordship. As per the FIR, Lordship, the petitioner name is not in the FIR, and subsequently, Lordship, his name is incorporated in the charge sheet, Lordship, as absconder accused, Lordship.
Charge sheet was filed on?
In the year of 2022. And Lordship, kindly come to page number
Shown him as an absconder.
Lordship.
Shown as
but
absconder, my lord. All these accused persons shown as absconder.
absconder, Lordship. But
And
my
it-
name is not FIR in the.
Regarding facts, my lord, your lordship may kindly peruse page 17 of this charge sheet, my lord. The victim statement recorded before the magistrate under section 164 of CRPC.
Yes. Then?
Well, my submission, Lordship, the petitioner is a lady, Lordship, and is a mother of 3 children, Lordship. And after 8 years, Lordship, charge sheet submitted, but police never visited and never tried to attempted to arrest her, Lordship. So, my Lord, and charge sheet already been submitted and next date fixed on 12/6/2026. So, my Lord, and protection may be given, Lordship, and she will cooperate and face the trial, Lordship. Any condition may be, Lordship. Otherwise, Lordship, her name is not in the FIR, Lordship. And 3 accused, Lordship, and there are in the FIR, Lordship, 2 phone number is, Lordship, been mentioned, but that is not from the petitioner, Lordship.
The
Also.
trial court.
So, my Lord,
And my lord, any order of the trial court has not been annexed here, my lord. The present stage.
but I have mentioned, Lordship, at the next date and in PRC number, Lordship, 20322, the next date fixed on 12/6/2022.
No, you have not annexed any order.
No, Lordship.
You have.
Only in the cost
You don't
title.
know
of the-
what is the going on.
But the appearance stage, Lordship, but
Huh?
in online, Lordship, I have some appearance stage.
So whatever, you have not annexed.
Lordship,
You have
appear,
not
Lordship.
annexed any order.
No, Lordship.
Whether they have.
You have filed, you have submitted that the charge sheet was submitted on 2022.
FIR in the year of 2014.
Huh? No, obviously, that I'm not on that. FR is on 14 and CS on 22.
Lordship.
From CS 22, what was the process of the court?
Lordship, and already put up Lordship, and the summon has been issued. And
On how many days someone issued, whether someone returned answer, whether NBW was there?
sorry, my lord, I have not annexed Lordship. I have not.
When you could be able to annex all this?
Next
Next.
week, Lordship.
Next week?
Lordship.
Next week, what are dates of? Monday, Tuesday, Wednesday, and date?
Lordship, I could.
Fourth.
Fourth Lordship, and the canon third.
Fourth,
Lordship, Lordship.
problematic. For
Problem.
all. In that case, 6.
6, Lordship. Lordship.
Well,
Deeply
listing it on
obliged.
6, you just file, we'll see.
Lordship. Lordship. Obliged.
List on 6.
Deeply obliged. Okay.
May it please your lordship. My lord, in a peculiar situation, my lord, the present petitioner before lordship.
Yes.
In fact, there was a dispute with his husband, with his wife, and on approach by the wife, there has been a compromise. And there was a compromise. As per in terms of the compromise, he is to pay 1,80,000 and monthly maintenance of rupees 2,000 to son. That he has been paying. But the wife, along with some other people, came to his house, vandalized his household properties. And in that connection, he lost a case that is Annexure 2, dated 15/4/2026. But the police, instead of investigating the case or registering the case of the petitioner, police is trying to arrest him. Therefore, we are apprehending, my lord. But no case has been, what is the case number, that has not been disclosed. My lord, we are in a difficult situation, my lord. My lord, at this stage, my lord, lordship may be kind enough to call for the report from the police, concerned police, my lord.
But what about your FIR?
My lord, my FIR has not been registered. That is Annexure 2. That has not been registered. It is from Borpeta Sodar Police Station. Borpeta. All right, I have annexed the court order and Annexure 1, then my FIR Annexure 2.
Yes, what?
At this stage, I will get a report, man. Otherwise, something is there because why?
Yeah.
Yeah.
Also hard is to be about an additional PPF on behalf of states. This is an application. The section 482. BNSS being for granting petitions. Next, right, is submitted by Mr. Sikdar that there was a dispute between the present petitioner and his wife. Accordingly, one maintenance case was also instituted by the wife of the petitioner, and he is still paying the maintenance to his wife and the children. But in spite of that, his wife, along with some others, came to his residence, attacked him and his family members, and also vandalized the house of the present petitioner. Thereafter, he lodged an FIR before the concerned police station, but that has not been raised by police. So, rather, police is harassing the present petitioner, for which he had to institute it the present petition. Next one. Mr. Bort would learn additional PP submitting this. A report may be called. From which police station? This
My lord,
Borpeta.
Borpeta Sodar Police Station.
Borpeta.
My lord, may I pray for an interim protection, not to take any coercive measure against the.
But what may be the reason? Because you are saying that you are paying maintenance.
Yes, my lord.
Everything is there.
Yes, my lord.
Thereafter also they have attacked you. Your houses has already been vandalized and all. And again, You are searching by police. Why?
My lord.
There has to be some.
That how can I say,
Next
my
week I
lord?
can get the report, man.
Okay, then
My
the
lord,
report.
may I pray for interim, my lord, not to take any coercive measure by the police, my lord. Police is searching me
Mm,
to arrest me.
Only not to provide any unnecessary harassment. No coercive
Yes.
action will be, my lord.
Report in next hearing the submission made by Land Council. In the hearing the submission made by Land Council for both sides. Again, later report be called for from the Porpeta Police Station, Porpeta Sodor Police Station, as to whether any case has been registered against the present petitioners. In the meantime, the police is also hereby asked not to harass the petitioners unnecessarily till it's fixed. Least the matter when it can be for
On my lord, 12,
12 of May.
Deep level, lordship.
May it please, my lord. This is an anticipated bail application, my lord. Lordship will find the FIR at page 9. So, my lord, there are two FIRs, my lord, here. Same victim, same accused, my lord. The other bail petition unfortunately got listed in some other court, my lord. That case diary has been called. Here, this is the first. Then, my lord, both the. That case diary has already been called.
Okay, when it is
It is on 8.
okay, we are
Then
listing
let
it
it
on
be
8.
fixed on 8. I'm not pressing for any training.
Okay, then we are listing it on 8. Along with you, just tell us the BA number.
B number. It is, it is AB number 816
816
public 26.
for the same victim. I mean, for
Same
the same
victim,
accused.
same accused. There are two FIRs.
Two FIR.
Two FIR. 816 public 26.
Same police station or different?
Actually, one is same police station, but there is one. First FIR was lost in the outpost of that police station, and second was in the main police station. So basically, same police station.
Okay.
816 AB 816 oblique 2026. It was fixed on. It is fixed on 8/5/2026.
Heard Mr. S.S. Sapit, the Direct Counsel for the petition. And also heard Mr. P. Wood, the Direct petition. Agreeing on behalf of state response. Considering this submission made by Mr. Ahmed, let the present petition be listed along with AB number 816 of 2026 on 8/5/2026.
22.
We are listing it on 8/5.
Yes. Obliged.
Yeah, please. It's an anticipated bail application also. In this matter, search sheet was being filed and the petitioner was being searched as an absconder. And the next date is fixed on 18/6/26 for appearance. It is in the appearance stage, Your Lordship. And the
18/6.
18/06/26, Your Lordship. The petitioner also here in Your Lordship has filed a cross case against the informant, Your Lordship. And the injury report that has, though the case has been registered under 326 and 307 of IPC, along with the other sections also. The injury report I have annexed here in page 41 to 45. All has been shown as a simple injury in it. And Lordship, moreover, the NBWA has been issued against the petitioner as he did not appear before the court after receiving the summons because the case is sessions triable, Your Lordship. 326 and 307 has been affected, though all the injuries are simple in nature. So my humble prayer, Lordship, he may be allowed to go on bail so that he can appear before the court and the case may be proceeded.
No, search sheet submitted on 30/11 page 50. 30/11/24. Incident they have not.
Have we annexed the order sheets here?
Yes.
53. My next date of
Yes.
appearance is on 18/6/26.
Where you have annexed the order?
Your Lordship will find the NBW order at page 50.
50.
50. Second
So you
order,
have
there.
annexed only one order.
That order, and also the lordship will find the other order at page 51, 52, 53. 53 is the date has been fixed on 18/06/26 for appearance.
File the order sheets. It's not this so easy process. List the matter on when it will be able to furnish. To an additional affidavit can
Within a week, Your Lord.
by the
Within 10 days.
within next week's house. Next date is on your
On
18th,
18/06/26.
11 will do.
Yes.
11 5 radio enabling the petitioner side to file the order sheets through an addition.
I'm sorry, Your Lordship. May I please, Your Lordship? Anticipatory bail application, Your Lordship will find the FIR at page 13, Lordship. The complainant suspected that his son died due to drug overdose because he suspects that his friends, which includes one of the petitioner before Lordship, they injected drugs to his son.
One
This is CD may be called for.
no CD was earlier called for no? This case.
CD called for.
No, no, no.
No,
First-
well,
This is the
first time listed.
first time listed, Lordship.
No. First time listed by for your petitioner.
Okay. For other
The
petitioners.
case was registered. Right? Dr. Area Seniki.
For other petitioners at page number 17, Your Lordship will find
Other
what-
petition page number 17.
17, one of the petitioner was granted absolute bail by this honorable court.
That's why I thought I can remember that one petition was earlier moved by someone, by you only.
Yes, but
Acha.
but it was Your Lordship granted interim protection, and then Honorable Justice Pranjal Das granted that protection. Same allegations against this petitioner also. Out of suspicion, he raised lost the FIR after 2 days of the alleged incident.
Drugs overdose.
Drugs overdose. There is
There are 4 numbers of accused person.
4 numbers of accused person. Actually, what has happened now, because the complainant, he filed a writ petition before this honorable court seeking a direction by the criminal investigation CID department. Now, in that particular writ petition, this honorable court issued notice, and therefore the police has started taking action now. And police, in fact, asked him on 18/4, the concerned investigating officer, he went to the residence of the petitioner. He asked him to appear before the investigating officer. But he is now apprehending that once he appears before investigating officer, he might be taken into custody.
So under which you have received any notice now?
No, nothing. Because it's more than 10 years, therefore, no notice can be issued. He'll appear before the investigating officer, Lordship.
Is Bothakur any submission?
One accused person, accused number three, my lord, in the FIR, he was already granted, my lord, the anticipatory bail. Absolute, my lord. that we-
There are, these boys were having most probably the drugs and all. I don't know how the overdose was there.
Yes, at
It
that
may
point of,
be injected by someone or it may be by himself also. That cannot be
yes,
said. at this
yes.
stage.
And otherwise, at that point of time, my lord, FSL report was not there in the case diary.
Not there.
Not there.
Heard Mr. Arbor, the learned petition. So heard Mr. B. What? The learned additional period being posted response. This is an application under section so and so in connection with so and so. Considering next submission made by the constitutional persons. This court of opinion that an opportunity may be given to the petitioner to appear before the IO and to cooperate in the investigation of this case. In view of this, interim to DDBO, is deliberate. ROCDB call for along with the medical and FSL. Oh, sorry, along with the PM report and the FSL. You appear before the IO, we are granting you influence.
On my lord, 22nd of May, my lord.
27.
Okay.
May I please, my lord? My lord, in this case, my lord, the FIR was lost in the year of 2013, my lord, December of 2013, my lord. Subsequent that the FIR, my lord, I was arrested, the executioner was arrested, my lord. In the year of 2014, my lord, I was released on bail, my lord, interim bail, my lord. Subsequent to that, my lord, that bail order was absolute, my lord. Now, my lord, after completion,
means you are anticipatory.
yeah, no, my lord, I was in behind the bar earlier, my lord.
Then 2014, you are granted bail.
Yes, my lord, granted. Initially, interim bail was granted, my lord. Subsequently, that, my lord, interimly released, my lord. Subsequent to that, bail order was absolute, my lord. And after, my lord, completion of the investigation, my lord, police personnel submitted the charge sheet, my lord. Now, my lord, during my appearance, my lord, I come to find that, my lord, there is no any record that I was in, my bail order was absolute, my lord. Even, my lord, there is no order in my bail order, my lord, earlier interim bail order, no absolute order with me, my lord, even, my lord, in the court record, my lord. It might be, my lord, earlier, my lord, this district was initially with the Dhubri district, my lord. At the relevant point of time, I filed my petition before the Dhubri additional session, the Dhubri, my lord. Subsequent to that, my lord, this come under the, my lord, South Salmana Mankasur district, my lord. Might have, my lord, record might be, my lord, misplaced or somewhat, my lord. Only order this, my lord, which shows that, my lord, I was in bail, my lord. This is on page 20A, my lord. This is the order, my lord, which shows that I was once upon a time, my lord, I was released on interim bail, my lord. This is only order, my lord. As per my lord information, my search, my lord, this is only the record, my lord, which we did the, my lord, court record, my lord, and nothing, my lord. My only problem now is that, my lord, this is a session trialable case, 364A, my lord. If I appeared before the, presently, my lord, it is case in committal stage, my lord. I appeared, my lord, there is every possibility that I may arrest, my lord. My lord. So, my lord, I humbly plead before lordship, my lord. I may allow to, my lord, bail this, allow my lord, anticipatory bail petition, my lord, that I may appear before the, my lord, committal court, my lord.
Your name is?
My name is, my lord, Akhirul Islam, alias Amirul Islam, alias Rose.
Mr. Bhattakur, if
Yes.
you go by the translated copy of the charge sheet, I don't know it is a proper or is if there is any.
Even, yes, my lord.
Thing
Even
is there.
charge sheet also not shown as a absconder, my lord. It's a
But
regular, my lord.
There also they will not shown as an absconder.
Yes, my lord.
Absconder.
Not shown.
Not
Yes,
shown.
Not shown as an
accused person
absconder. They were
sent up for trial.
sent up for trial in custody and bail was recognized.
My lord.
Then how it is not there? I don't know from where you are saying. It is you're sent up. You're not shown as an absconder there.
Then
Yes, my lord. But my lord, court asks that you should have to produce the absolute bail order, my lord. That is not with me, my lord.
if
That is
suppose,
the
my lord,
problem.
that order, page 20, my lord, after obtaining interim order, he has appeared before the trial court.
Yes.
Thereafter, probably proceedings of the trial court, my lord, since 2014 till now, my lord, proceedings, my lord, going on.
But my lord, there is no such record, my lord.
CS file on which year? CS file on?
My lord, CS file on 30/12, 2017, my 28 to 2017.
17, my lord. Yes.
Now, my lord, it is start for the trial, my lord. In the separate, in the now presently,
But nowhere,
district, my lord.
nowhere, my lord, in the search sheet also he has shown as absconder. My lord.
Not shown as.
Not
My-
shown as absconder. So
So now what is your problem now?
My problem is that, my lord, this is a session trialable case, my lord. I have
Session trial is okay. What is your problem?
My lord, I have no absolute bail order, my lord. Court asked me to produce the absolute bail order, my lord. Otherwise, I put behind you bar, my lord. That is my problem, my lord.
Though the entire record was not sent up before South Salmara.
Even, my lord, my counsel also personally inquired in the Dhubri district also. There also he failed to find, my lord, any such record, my lord.
Record is not there.
No, my lord, might have bail order might have destroyed, my lord, long back, my lord.
It could be difficult. How if my lord records is not there, he is in interim, absolute.
And lordship may call for record, my lord. If my lord
Only
land is to be object, my lord.
Scan
Just
copy of
call-
PCR may be called for.
My lord,
We'll call for the record.
actually, my lord, I annex the entire record, my lord. That is the record, only record, my lord, who is available present in the before the learned JMFC, my lord.
So JMFC received the charge sheet.
My lord.
As per you, initially you were in Dhubri
Yes,
district.
Dhubri district, my lord.
Order was
Last
there,
it-
and when after filing of the charge sheet, the case was transmitted to South
Yes,
Salmara.
my lord.
South Salmara might have there maybe record. I think.
Yes, my lord. Otherwise, how that record came? My lord?
Because you are not shown as an absconder, you are on bail.
Yes, my lord.
It seems as from the
Yes,
FIR
yes, my
in
lord.
the charge sheet that
My
you
lord.
are on bail.
Yes, my lord. Otherwise,
Bail was recognized.
I ought to have shown as absconder, my lord.
Otherwise, you are
My lord.
not shown as an absconder.
Not shown as absconder in this. I mean, at least a scan copy of PCR may be called for. My lord.
Where from it has to now South
South Salmara, my lord.
South
JMFC, South Salmara.
JMFC South Salmara.
Yes, my lord.
I mean, case is not yet committed.
No, my lord.
So because of you,
My lord. Another some accused also not appeared, my lord. Last order, my lord. That is, my lord, some 10 to 26, my lord. Some fixed for appearance, my lord. Some other accused.
Along with the present status of the case. Present status.
Actually, my lord, case is fixed today, my lord, for appearance. My lord.
Scan copy of the teacher along with the case diary and the present status report we call for from the court of where it is pending now.
JMFC, South Salmara, my lord. South Salmara, Manka, sorry, SS.
JMFC South Salmara. One. Registry will do the needful. Yes. 7th of this month. Well, it's
My lord. Obligement.
My lord,
CD is necessary, lordship. I am appearing for a private respondent, respondent number 226. I have already submitted my affidavit in opposition.
prayer for cancellation of bail.
Prayer for bail cancel, yes.
my lord,
226.
granting bail or rejecting bail, my lord, I can understand that's a discretion of a court, my lord. But in this case, the manner, my lord will kindly appreciate two facts because I was the counsel before.
Without CD, my lord, today, my lord.
No, we are not going to
CD.
You have annexed the bail order, earlier bail order.
I have annexed the bail order and the subsequent orders, my lord. My lord, the issue is this. We are not on the merit of the allegation. My lord, on 16/2/2026, 3 people were arrested under section grievous hurt, 10 years. A life imprisonment is there. Then criminal trespass. Then house lurking trespass, 10 years imprisonment. These were the sections. They were produced before the learned magistrate on 6/2. On 6/2, no bail application was pending before the court. They were remanded to judicial custody, and they were with the direction that they will be produced on the very next day. Normally after 14 days, my lord, that is what we know, my lord. The very next day, that is on 17/2, they were produced, my lord. I, in the sense, truly me, Mr. M. Biswas, I was engaged as a counsel by my client to oppose the bail. I said, okay. I went to the court of the concerned court below. Till 12 o'clock, I could not find any bail application. So I thought maybe nobody has filed any bail application. But around 2 o'clock, I have come to know that a bail application has been filed and the hearing was in the chamber of the judge. I asked the court master that I am appearing for the informant. I also want to go to give my submissions. The court master then informed me that since it is the other side is the state, so there is no scope for a private counsel hearing. And at 4:30, I have come to know that bail was granted. Do my client don't have a right of audience? I have Supreme Court judgment, my lord, which say that informant can participate in the criminal procedure from the very inception. My lord, whatever maybe, my lord, I am also appearing for petitioner for praying for bail, my lord, in hundreds of cases, my lord. Granting bail is not the way. The manner, justice is not only to be done, it must be seen to have been done. And my lord, this is, my lord, I must indicate, my lord, in most of the, I have seen in most of the courts below, there are this chamber hearing, my lord. In most of the, I have seen, not every, my lord, but there is, my lord, there has to be some guideline, my lord, because going inside a chamber of a judge and hearing.
Within Assam, you have seen this kind
Yes, yes, my lord. Yes, ma'am.
chamber hearing.
Yes, there are
Especially bail hearing is also
bail
in the
applications are taken up in the chambers sometimes. I'm not saying all, but this is one concrete case which I have at hand.
Bail applications are also in the chamber hearing.
Sometimes, my lord, sometimes I have seen, my lord, but I don't precisely remember. But this is a warning example, my lord. This is one which I am appearing. Because here the hearing was taken in the chamber and they filed their affidavit, they did not deny.
Earlier, your notification was also there that no chamber hearing is preferable, no chamber hearing should be there.
Absolutely.
Because except the camera trial and all.
Absolutely. On camera is a different.
Camera is different.
This is my lord, this is a concrete example. In fact, my lord, they have filed their affidavit, they have also not denied. And why should I lie, my lord, before the High Court? And when I am saying I have written it my name. I personally, I was the counsel. It's not that I have heard it from somewhere. I was the counsel. What would be the situation of a counsel, my lord, before his clients? That you are not even, you were given, you have not even submitted anything. You are not even given an opportunity. My lord, we have also done our LLB from recognized universities, my lord. It's not that we have degrees from some other.
Anyway, you are appearing. You are appearing.
Yes.
For
Yes.
respondent, private respondent, 2, 3.
Yes, Lord.
Five
We have
days.
submitted our opposition.
You have
Thing
already
is that
filed it.
we believe if your lordship see the order which is made impugned here, nowhere they are supposed to be prejudiced, lordship.
No, it's okay. Now you have already filed your objection here.
Yes, we have already filed our
You
objection.
need the CD here or?
Yes, we need the CD, yes, Lord. Because after going through the CD, the learned magistrate granted the bail.
My lord, otherwise, yes, I just now I have gone through the, my lord, his petitions, my lord, regarding that the order was in absence of the present petitioner, that order was passed, my lord. All those things. Anyway, my lord, while cancellation of bail, I will also have to go through the CD, my lord, regarding those allegations, my lord, that without hearing the present petitioner, bail was granted, my lord. Although I will have to see, my lord, those allegations. My lord.
The issue is this, my
Because
lord.
in bail cancellation, there has to be,
because
you have to
yeah,
see the.
in presence of the, my lord.
In presence.
Okay, then from where it has to come?
Amingaon, my lord.
Amingaon?
Come from the Amingaon.
Otherwise, you have filed your objection, na?
Segaon police station.
You have already filed your objection.
Otherwise,
Yes.
if he wants to, my lord,
Segaon police station. Yes.
he in fact made specific allegation against the court also.
This is not allegation. I'm stating fact. I'm not alleging that somebody have died. I'm not imputing any motive. I'm stating fact.
Yes, my lord. Otherwise, any date may be fixed out that I will get the CD, man. Anyway, otherwise, to my lord, find out regarding those, like the CD will also not deal with all those my lord statements which he has.
Actually, CD will in this case, my lord, I don't think CD
Only
will.
CD will only say about the materials which are there.
The orders will show.
Accused person, but.
My lord, why the personal presence of accused are required when there is no bail application pending before the court? He was produced on 16. He was sent to judicial custody. Again, why reproduction on 17? Where is the provision? After 14 days, that is what we know, my lord. I can understand if there is a bail application, assuming that there is a bail application pending. Even then, why the presence of the accused is required? That the case that comes.
Order sheets you have already.
Yes, yes, I have annexed. I can show from the order sheet.
Is whatever the order sheets also we need.
Yes.
In that case, the copy record CD will show you something else on the merit.
Yes, yes.
And
But
the
what
record of bail
procedural
application.
Things, as Mr. Biswas
That
is
has to be
raised,
my lord call for from the trial that court my lord
trial
scan
court
copy of
record.
it. Yes. Order.
Scan copy of the trial court record also call for. So in that case, two things will be there. You have to call for the case diary and the registry.
Yes,
Call
have
for
to
the
call for the my lord, till now present status of the case along with the my lord, till now whatever order passed in that case my lord from the trial.
My lord, the better thing according to me would be the record of the bail application.
The record of the yes.
The record of the bail application which has been disposed of by the learned
Yes,
trial court.
yes.
he is any miscase was
Now,
registered in that case?
as per the impugned order, if your lordship sees,
Where in page
impugned order, 25.
25.
I don't see any miscase here.
Miscase is
No, it is not numbered anything. Kiba number apuni paise nahi sakte. Yes, petition number 351.
Petition number is there, whether miscase is registered.
No, miscase is not raised.
Okay.
Your lordship make call for the case record along with the detailed order, along with the order of the death bail application, scan copy what order passed on that. Everything will, if everything will come, then will reflect the entire scenario.
Because the matter has not been charge sheeted, so as such there will be no record. Save and accept the petition number 351 and the order dated 17/2.
No, we maintain a record. CD is there, we maintain a record when suppose the production date is there. So definitely one order will be there. If any bail order is there, then the order.
Then the entire
record will be, we maintain a record. So it's the scan copy of the DCR in connection with Soigaon PS case number 39 of the 2026. We call for registry using it. In the meantime, the additional people will also call for a case diary in connection with the Soigaon PS case number 39 of the 2026. This the matter. When can we?
My lord, any date as per his convenience, my lord, I can get it.
Yes, because they are in bail.
Yes.
There's no issue, other issue.
Otherwise, one difficulty.
They are on bail, so you can.
Let them be on bail.
One difficulty is there. Well, he has only informed them. I am just only saying he has only informed the court master that I am appearing on behalf of the accused to object the bail petition. Probably whether learned court aware about the presence of the my lord, at that point, whether he has filed any application, my lord, any ukalatnama, whether I am going to appear on behalf of the accused, those things also my lord need to be looked into.
My lord, I don't wish to counter him on facts.
No,
my lord, when can, my lord, the judge has to be there in the court. Then only I can appear before him. Number one. Number two, wakalatnama in which case? Till 12 o'clock there was no bail application. Then when I heard that the bail application is filed, the wakalatnama was in my hand. My lord, I was personally present there. Anyways, my lord, have called for the record. We'll see the manner.
And otherwise, if PP would have been there, if you would have
even PP namo nahi aate.
Appearing on behalf of the my lord, assisting PP, then PP also, my lord.
Even the name of the PP is also not there in the impugned order.
Anyway, my lord,
I have my doubt whether there was any PP.
let the record may come on.
PP submission is not recorded here.
Yes. Because, my lord, I have one of my friend is also a PP in that court, my lord, my classmate, my lord. I took his aid. He told me that on that day, that PP of that particular court was on leave. But I don't go into all these facts. I have not written it in my brief. Whatever I have written, I stand by that. I, Monojit Biswas, I was there in the court. I was denied a right to audience.
Name of the court. Name of the court. CTM, Kamrup Aminko. Officer will say Mr. Sri D. Bhuyan.
I'm going to copy it and yours.
Yes,
CD to call to
PS 39.
copy asking yes. धन्यवाद
कॉपी लगेगा
कॉपी तरह
जेरॉक्स पर भी दो।
11. 11. Listing. I have heard something about the other officers in Kamrup Amingao, in fact. So we have to take some steps. I have heard the other matters about the Kamrup Amingao, not Kamrup Metro. I will see to it. If such kind of practice is going on, that should not be. I personally do not support.
My lord, just out of this, my lord, I have appeared in Itanagar lower courts, my lord. Wonderful system. There is a cause list. We know which item will be called when. One day beforehand.
That should be.
It's so wonderful, my lord. It's to APR. I have even
chamber practice, as far as practicable, it should be
avoided.
Unnecessary why controversy should be there. If the open court, it has to be.
Yes.
Hear the matter in the open court, any matter, except the camera trial or 164, that is different. Otherwise, you can hear. Even suppose in cases their privacy has to be maintained, in that case, different things.
Those are different.
Other civil matters, criminal matter, or has to be before the court itself.
It has to be before the open. Otherwise,
yes,
also, my lord, somewhere it hurts the dignity of a lawyer, my lord. Going inside a chamber and standing like this and making submission. Somebody is sitting, some police officer is standing here. Somehow, it's not that much.
Okay, we'll be listing it on 11th of May. Let
Absolutely.
us see. I will personally inquire.
11th of May.
Your lordship may fix it on 12 of May, 12.
12th of May.
Okay, that's 12.
I am deeply obliged, ma'am.
Forcefully. That should not be Namibia. One time. It's not Namibia. Nothing to try to move on. Moi ini mon gusto mo chamber pa ni. Ano ko ano? Kaya yung CTM. Dijeng ko chamber pa ni ba? Hello. Puro kalpo. Man dito puro pa kalpo. Yes, Mr. Mit.
May I please, Your Lordship?
Yes.
Lordship, the subsequent bail application, second application, Lordship. Lordship, earlier one was rejected on 6/2/26, Lordship. On the ground which it was rejected, Lordship, the ground was taken, non-furnishing of 48 notice, Lordship. The grounds of arrest were not furnished, and accordingly that petition was disposed of. Now, coming up with this petition, Lordship, we have taken fresh grounds, Lordship. Lordship, the fact of the case is that, Lordship, the present petitioner has been behind the bar since 530 days, Lordship, and it is precisely 1 year, 5 months, and 14 days, Lordship. The contraband that has been recovered, Lordship,
is 1 year?
1 year,
2 years.
5 months, and 14 days, Lordship. 530 days, Lordship. And until now, Lordship,
Not a single witness is recorded, Lordship. And charge sheet has been laid on, Lordship. Uh, 34/25, Lordship. Charge sheet has been laid on 34/2025, Lordship. Recovery of contraband is, Lordship, 10,000 suspected Yaba tablet, Lordship. Now the fresh grounds that has been taken through this petition, Lordship, Lordship will find on page 29, Lordship, regarding the arrest memo, Lordship. The mandate which has been given through the Supreme Court and various Supreme Court judgment, specifically on DK Basu, Lordship, DK Basu case, Lordship, there has to be a attesting witness, Lordship, in an arrest memo, Lordship. Lordship has found the arrest memo, Lordship. There is no attesting witness in the arrest memo. Lordship, I have submitted several, Lordship, coordinate bench order where it has categorically, Lordship, stated in DK Basu also in the coordinate bench order also, Lordship, that if there is a no attesting witness, then it is a direct violation of Article 21 and Article 22 of Constitution, Lordship. Which vitiate the arrest, Lordship. In the coordinate bench order, Lordship, various coordinate bench order, DK Basu has been observed, and similarly bails were granted in this ground, Lordship. The other ground, Lordship, which I have taken, Lordship, is about Muhammad Muslim, Lordship, where delay trial, Lordship. As not a single witness has been recorded until now, Lordship. What Muhammad Muslim says, Lordship, I have submitted, Lordship. Grant of bail on the ground of undue delay in trial cannot be said to be fettered by Section 37 of this Act. And similarly, Lordship, the coordinate bench of Honorable Gauhati High Court has granted bail, Lordship. In bail application 3332, which I have submitted before your Lordship. These are the fresh grounds which I have taken, and upon violation of this arrest memo procedure, it's a clear violation of Article 21 and 22, Lordship. And it not only violates Article 36 of BNSS, while if there is no attesting witness, it also violates it not only violates Section 36, it also violates Section 62, Lordship, which says that arrest has to be made strictly in accordance with the Sanhita. I have gone through the CIS records. I have found out no witness has been recorded, but LCR will speak, Lordship. In various observation, it is also mentioned that when Section 36 and Section 62 is subsequently violated, are only statutory exposition of constitutional norm provided under Article 21 of the Constitution of India, and same cannot be overridden merely because of the presence of non-obstacle clause in Section 37 of the NDPS Act. It is observed in bail application 3650 in page 10, Lordship. Rejection.
May I please, Your Lordship? It's Lordship, regarding the 4748, the Lordship has already made it clear in the earlier, my lord, my lord, in the earlier order, my lord, that my lord, 4748 is duly complied with, my lord. That has been my lord observation by Your Lordship's order, my lord. So, my lord, that ground is not available now at this stage, my lord, because Your Lordship has already decided.
I'm not
Going, yes, my lord. Now going to the 36, my lord. My lord, what 36, my lord? There is also a decision rendered by Your Lordship, my lord, regarding 36, my lord. I am just reading the paragraph, my lord, 12. It is BA number 4068 oblique 25. My lord. I will hand over the copy, my lord. My lord, in the same time, it is also the case of the petitioner that every arrest has to be in accordance with the Sanhita under 62 of the BNS. It is a fact that while issuing the arrest memo under 36 of BNS, every detail of arrest has been mentioned. However, no signature is obtained from the family, but it is seen from the record as well as the bail order. But this is the case here also. It is seen from the record as well as the bail order passed earlier that there is sufficient compliance of 4748 of BNS 2023, and it is seen that the accused persons were well aware of their grounds of arrest and their family members were also accordingly intimated through a notice under section 48 of BNS. Thus, it is not a fit case that any prejudice is caused to present petitioners only for non-compliance of 36 of the BNS 2023 when there is sufficient compliance of 47 and 48 of BNS 2023, and the family members or relatives of the accused persons, petitioners, were also intimated regarding the grounds of arrest of the petitioner. That apart, it is also seen that the arrest memo as well as the notices under 47 of the BNSS 2023, the signature of present petitioners were obtained intimating the petitioners regarding their grounds of arrest. And paragraph 14, my lord, Your Lordship has, in the case of State of Karnataka versus Darshan, etc., reported in 2025 SCC online SC 17002, it has been observed that compliance of the requirement under section 4740 of BNS 2020 is sufficient unless demonstrable prejudice is shown. Accordingly, it is seen that no prejudice has been caused to the present accused petitioners only because of non-obtaining the signature of the family members or relatives of the accused person. It is complying under section 36B of BNS 2023. And that is, since no prejudice could be shown, because conjointly reading of the 47, 48, and 36, it is seen that there is no violation of Article 21, which has been rendered, because Lordship can see after his arrest, after her arrest, she was, if I go to the order of the, what the order of the trial court says, just I'm reading it. Order dated, the trial court is with me, my record is with me, just I'm reading, Order dated 13/11/2024, The accused persons, namely Hasumia, Amina Khatun, and such are produced before me. I'm giving, I have seen and perused the forwarding report, arrest memos, inspection memos, notices under section 47 and 48 of BNS, and WT messages. In the present case, IO is present before the court along with the case I have perused. I have seen the medical report assessors. The accused persons are made aware of the legal rights. They have stated that they will engage their own counsels. That is the order of the trial court. Thereafter, my lord, I'm skipping in between, my lord. Now, let's see the petition number such and such filed on behalf of the accused person, wherein prayer has been made to enlarge them on bail. And that is what the mandate of the law is, madam. They has to be represented on the day of their production, madam. That is very much here from the order, madam. Because in the petition number such and such, on behalf of the accused person, wherein prayer has been made to enlarge them on bail, madam. Now and this prayer has been rejected, my lord. Bail is not granted. So thereafter, my lord, Lordship may just I am producing one judgment of the Lordship coordinate bench, my lord. That is in BA. Lordship may kindly record BA 887 of 2026. It was decided on 23/4, just 3-4 days back. May I read, my lord, regarding 36? But to see, my lord. Lordship may kindly record BA 887 of 2026. Para 14, my lord. What clause C of section 36 BNSS requires is that if the arrest memo is not signed, attested by a member of his family, then he is to be informed that he has a right to have a relative or a friend or any other person named by him to inform of his arrest. This requirement stands duly compliant as the arrested authority has itself informed the wife of the arrestee about his arrest by way of notice under section 48. With regard to other submission of additional PP, this is not required in para 6. In view of the aforesaid risk, I am of the view the absence of signature of witnesses as mentioned in section 36 BNSS on the arrest memo does not ipso facto vitiate the arrest nor renders it illegal. Furthermore, in view of the fact that commercial quantity of contraband was recovered from the position of the petitioner, rigors of section 37 are squarely affected. And based on the materials available on record, there is no ground to come to a view the petitioner may not be guilty of the alleged offense. So first, this according to this order, 36 has been complied with. I am relying on, and also it says about the section 37, which is in this case also. He was caught with red-handed with nearly 10,000 suspected tablets and also heroin. He is not a consumer. He is not a. Here, section 37 cannot override the embargo, because and also, I am relying on another judgment of the Honorable Supreme Court, that is State of Punjab. It is arising out of SLP 5020. SLP criminal number 5020 of 2026. That is my State of Punjab versus Sukhvinder Singh Bora. Just gist I am just saying, my lord. Just I'm giving the gist of what they said, madam. The Supreme Court has held that a right to speedy trial under Article 21 cannot override the stringent statutory requirements for grant of bail under the NDPS Act 1987, madam. That is specifically, madam, dealt, madam, regarding, and that is regarding the detention he has been claiming, madam. And here, madam, in this paragraph, madam, 9 and 10, this specifically, madam, mentioned, madam. May I? Third paragraph, may I read, madam? It is well settled that in matters involving recovery of contraband in commercial quantity, the twin conditions under section 37 are mandatory and entail no relaxation merely on the ground that the accused has undergone prolonged incarceration during the pendency of trial. The provisions cast upon the court a duty to record before enlarging an accused on bail its satisfaction on two cumulative conditions. First, that there exists reasonable grounds for believing that the accused is not guilty of the offense, and second, that he is not likely to commit any offense while on bail. The recording of such satisfaction is not a mere formality, but a mandatory precondition, the non-observance of which vitiates a grant of bail. This court in Kasib has held in no uncertain terms that a recording of satisfaction the twin conditions under section 37 is mandatory and not merely directory, and that an order granting bail without such record satisfaction stands vitiated cannot be sustained. And paragraph 10, the impugn order on its own showing does not record the satisfaction under section such and such. Far from recording such satisfaction, the High Court has gone to observe the rigors of 37 of NDPS can be diluted, bearing in mind the right to speedy trial. Such an approach is plainly contrary to the settled law laid down by this court and deserves to be set aside on this ground alone. The right to spirit right rooted in Article 20 of Constitution is undoubtedly precious in the right. That right, it matters governed by special enactments such as NDPS Act, particularly where recovery is of commercial quantity. The said right must be exercised within the framework of Section 37 and cannot be placed into service solely on the ground of delay to override it. That means very specifically stated that even if it is though I even assuming the delay, because perhaps it cannot be said that there is inordinate delay in the trial. This is not a case before lawsuit that he is behind a wall 4 to 5 years, and no trial is being held. This is not a case, and lawsuit may kindly say dates, The search sheet was filed on 13/12, 3/4/25. Thereafter, charges were framed on 37. Thereafter, now trial is begun,
No,
So
thereafter no witnesses record.
no witnesses record. That is from the record you also will find. But it is not a case that he is languishing in jail for more than 2-3 years, where a thinking has to be made that the section tradition whether it will be override or not. But this is not a case here, And also from the order of this and also from the order of this observation from the Honorable Apex Court is very much clear, that PD trial cannot be overridden the embargo of Section 37, and that your lordship will find, and your lordship also, in I am giving the judgment.
Lordship, regarding that, the judgment which has been placed, Lordship, at the prosecution. Lordship, there is a recent judgment, Lordship, I will place. Lordship may give us some time, Lordship. Next week, Lordship, I will place a recent judgment, Lordship.
And your Section 37 also, my lordship, in your lordship's own judgment, in the earlier round of litigation, Section 37, the lordship has held that,
Which regard you want to
regarding
submit,
yes, Section 37.
other?
Yes, Lordship.
Which regard?
Lordship, in regard to the prolonged incarceration, there is a recent judgment I will place. Lordship,
That is what my prolonged incarceration can be looked into when there is specific violation of Article 21. That there is no trial at all. That cannot be a ground here because it is the search sheet. Thereafter charges were framed within 1 year. Now the trial is begun, And lordship, last order, she was well aware committed, his sin, she was well aware about the offense she committed, and it is a case of a commercial quantity, and hence a rigor of 37 will also attract in this case. He further submitted considering the materials of the case that it cannot be held that she is not involved in the alleged offense. At the same time, there cannot be any reasonable ground that she will not commit similar offense in the future, That is the twin conditions, Because you can see that a huge quantity of 10,000 Yaga tablets, not a cannot be turned as a joke, So at this stage, and the judgment is of 24/4/2026. Honorable Apex Court judgment, that I have submitted.
I will go through the judgment also, Lordship. And I have a similar judgment in my mind, Lordship, that I will place on next date, Lordship. I may be given some time, but next week.
No, only for the purpose of submitting a judgment, perhaps no more arguments may be
Lordship, I will argue,
required.
Lordship. Next date may be given, but I may not be reserved, Lordship.
Order may not be reserved.
Because
You want a date.
Yes, Lord.
Because only he can submit a judgment which he is relying on, otherwise everything is before the record, before
I have
lordship.
already recorded also.
Yes, lordship.
Otherwise, he took 2, 3 grounds, new grounds. We have already
Yes, 36 I have addressed, my lord.
yes submitted.
And long incarceration and 36 notice.
36.
These two are he has taken, my lord.
Long incarceration, section
Long
36 and
And
62.
36 is the main ground most
These are
probably.
already decided.
The SLP criminal you have already given, na?
SLP already given. And our High Court judgment also 23 for 2, 3 days back. Same observation. And squarely covers these facts of this case, madam. He has put his signature, madam. I have flag marked the, my lord, the relevant portion of the ECR, my lord, and also order of the learned trial court.
Okay, when you need
Next week, Lord. Any date, Lord.
6th of May.
Deeply ordered.
Don't repeat all this. I have already.
No, I will not repeat on that. Lord.
Simply you filed. I am
Yes.
not reserving the order. That's why.
Yes.
As there may be the change of any situations.
Yes, Lord.
Circumstances, so
I will not
am
repeat on 36.
reserve the order. Only will you argue on that.
Deeply ordered.
6th May.
Published.
This 6th May. Select.
Case 10 is the effect.
Yes.
Herein only the name of the petitioner number 1 is mentioned as accused in this FIR. In the petition number 2, his name is not in the FIR. And only the allegation is that on the day of Alice incident, the nearby shopkeepers of the informant informed the informant that the accused petitioner number 1 entered into the shop of the informant. And thereafter the informant came and found the accused petitioner number 1 entered inside the shop of the informant. And thereafter he was caught red-handed and subsequently handed over to the police. And it is the allegation on. And the next part is that there were 2 accused, one taking advantage of darkness, lead away. And so the petition number 1, he was arrested, he was caught red-handed by the public and handed over to the police. And on 18 to 2026, he was forwarded before the court. And the petition number 2, he was arrested from his home, from his home, and that is also on 22 to 2026. And nothing was recovered from them. And in the meantime, the sheet has already submitted. And the present status of the case is the status case. I think the TCR is listening. Search. So I am only praying, Your Lordship, since the search sheet has already submitted, Your Lordship, and let they maybe allowed to contest the trial, Your Lordship.
They along with the others also entered into shop of another shop, Jagannath Jewelers.
That means it is in the FIR, Your Lordship, that there was 2 persons.
I
But
mean,
only the
proper
petition number
docket
1,
or
he was,
robbery was done.
yes, only the petition number 1, he was caught red-handed, Your Lordship.
Yes.
There are 2 accused. Refer to the matter, forwarding report, matter, and the petition, page 17.
Here.
And the document kindly down to correct. He committed offense under section the morning of 17th Tiger Market. The accused and his associates are committed theft on Thursday jewelry shop by stealing 9 silver chains, 6 pairs silver other jewelry items. Further attempt to commit further theft in New Piran jewelry shop by breaking open the lock. At that time, owner and recovered and recovered stolen items along with motorcycle and firearms from according to and third is my mechanism. He is a veteran theft committed theft. He is in many areas. The accused is involved in below multiple similar cases of breaking and theft. The document found the numbers 1, 2, 3, 4, 5, 7 cases are registered. The same offense. So my first type of sympathy is my now my clear responding and also comparing with the evidence in it is not
This is the foreign report of Wahoo. Petition number 1.
One.
Rakesh.
Petition number 1, Your
One,
Lordship.
Therefore, after his arrest, my investigation came out, my lord. They are in a group, my lord. One is 34, Rakesh. Another person is there. He is as per the thirsty. This one as the present petitioner, and another was Dulal. Petitioners are found involved in the execution of the crime. And from the thirsty, for the investigation, in the accused person, the 9 silver chains, 8 silver, 6 silver pies, 8 metric silver, other jewelry items, some thereafter they will be at this age of 30 down at this age of my at this stage, considering the their nature and gravity of the offense, they are not there one type of freedom. Considering that, maybe it's not it is at least after
Herein, Your Lordship, in respect of the petition number 2, Your Lordship, there is no any case. But yes, admittedly, Your Lordship, in respect of the petition number 1, some cases are there, which is written in the prohibiting report. But I am praying only because since the case has already been succeeded, Your Lordship.
Petition number 2's forwarding.
Forwarding
Press 19, Your Lordship.
19.
Yeah. 19.
No, your petitions come is
and there are two in this petition also 2 petitioners.
Two
One
petitions.
Rakesh and another is
One is Rakesh and one is
Horrible Islam. And page 19 is the frauding report. This is in respect of the petition number.
submitted. The petition was alleged to have got rehanded by legal public without any specific reason. However, both the petitioners are in custody since 68 and 64 days respectively, and hence further custodial detention of the present petitioners may not be necessary for the purpose of the petitioners being from the same locality. They will appear before the grand court as and when they speak. There is some allegation against the petitioner number one, who was stated to be represented by public. There is no such specific allegation against the petitioner, but he has been implicated falsely and arrested. The case has already been charged, and thus there is no chance of tampering or tampering with the investigation of this case at this stage. Both the petitioners are ready and willing to produce their proper bail. They're ready to produce the proper bailer and surety, and will abide by all terms and conditions imposed. Mr. Goswami did not remain objection submitted that the bail prayer for the petition may not be considered. The record is it reveals that petition the petition committed two incident of equity the very date of incident, and while leaving the house trying to commit equity in the house of the informant, the petition number one got red-handed by public. So it's further submitted that recording report of the petitioner number one. So it's seen that apart from this, there are 7 numbers of other cases also being pending petitioner for the same kind of office. The petitioner number six is also involved in the alleged on the night of incident. He, along with the petitioner number one and some other, committed robbery of the Gauhati 3 houses on the same night. Some of the dead are being recovered from the person. There is every chance of absconding if they are granted bail at this time. According to Mr. Musa, stated that case is picked for consideration of charge, and till that prosecution could not examine any witnesses, and hence bail may not be considered at this stage, as there is not only a chance of absconding, so there may be a chance of tampering with the independence. Take the submission made by it's is to petitioner had alleged of the community into the houses in the night of incident and night of incident, and the on the day of incident, the petitioner also got arrested, got apprehended by them. The recording report also explained that this is in case against the petition. There are as many as 8 numbers of other matters spent for similar time. The petition number 2 is also could be involved in the arrest of and was present along with the this court is of opinion that probability of outcome tampering with the evidences and
In respect of petition number 2, Your Lordship, there is no any case and his name is also not mentioned in the FIR and he was arrested from his home.
further from this statement by the accused themselves, it is seen that the Dulal is the accused number 2, na?
Dulal is not before.
No, no.
Not before.
Oh, acha, acha. Who is next one is?
Sharif is my lord.
Oh, Sharif.
Again.
They committed jewelry shop of Gauhati. They committed, they attempted to commit another theft of the property in the in the jewelry shop of the president. When they got when the petitioner number 1 got revenge and the petitioner number 2 managed to escape from this. Considering all these aspects of conduct of the nature that the probability of absconding So bail petitions for both the petitioners are rejected.
All right.
All right.
Yes, 21. We have received the record here.
Did not receive, my lord.
Not received. You were on interim.
Interim. Two petitioners here. There.
Two petitioners are there.
Two petitioners.
Both the petitioners are on interim.
Number 4. The
They did not receive. Just remind me. Yes.
My lord, lordship. Taken up, my lord. After 2 weeks, any date.
13th of May.
Good.
Next.
Interim be completed till next.
May well. Just to kindly pass over for the time being list.
23. You have received the case
CD
diary.
received.
Okay. What is the position on 26?
Lordship, Madam, may pass over for the time being. My senior
26,
listener.
my lord, case diary not received. My lord.
Is there not?
Up to date case diary not received.
You are on interim, we are extending your interim.
Lordship,
You are on interim, we are extending your interim. Case diary not received.
Lordship, my senior likes another code, Lordship. I am not aware.
Interim.
Interim was there, yes.
Yes. The interim may be
Now, see,
continued.
we are not passing any adverse order against you. The question is that you may not be aware of, but the matter was fixed for case diary. We have not received the case diary. On the other hand, you are on interim, so we are extending your interim. That much. Okay,
Well, 26 and 27 same.
Same only.
same. You are appearing in both. Same order. Say the note, just remind. Yes, board.
On 22/5, my lord.
Yes,
No,
Mr. Kalita, we have not received the case diary.
yes,
So, date next is 22.
yes.
Interim order is that.
Yes, yes, we'll extending your interim.
Lodge.
22/5 interim be extended till next time. We're extending your interim.
Lodge. Of like
22/5.
27. You are for the informant.
Yes.
What you have submitted?
Yes. CD received. my- Even
After
timing,
what
Lord.
time you say?
time.
Time being, Lord.
Achha.
Yes, thank you, sir.
Oh.
Should the matter may be passed over for the time being?
Yes.
The matter may be passed over for time.
What is the position of this?
CD received. my-
CD receipt.
Seriously. It is your lordship. Your lordship, I have a small submission, your lordship. Your lordship, on last occasion, this honorable court was pleased to pass an interim order, and today the matter was listed for the case diary. However, your lordship, despite our best efforts, we have not been yet received any instructions from the petitioner. In that case, your lordship, I may kindly seek appropriate direction from this honorable.
Well, in this case, final report submitted. my lord. FR submitted.
FR.
FR. Finally.
Petitioner was one Surinder Sharma.
Surrender.
Surinder Shah.
So if final report is already there, we are not, this matter may not be pending before us. We'll dispose of the matter. If the case has already been ended with FR, final report. So at present, there is no case against you.
Yes.
And if you receive any summon or notice from the learned trial court below, if any Naraji case, in case any Naraji is filed, then it will be taken up by the learned trial court. So at this stage, we are going to dispose of it.
Yes.
But
You are MS?
M. Agarwal.
M. Agarwal. RMS M. Agarwal, the learned counsel. Mr. P. Board, the learned counsel. It was fixed of case diary, but submitted by Mr. Board. That cases of the FR has already been submitted in the case. FR, is there any
FR number, my lord, 18/26, dated 15/4/26. This report may kindly keep as a
Yes.
part of.
FR has obtained so, and they submitted that at present there is no case against the present petition. The deputy message by which it was informed by the IO also be kept with the case. Next, as the case has already been ended with FR against the present petitioner, the present anticipatory bail application for anticipatory bail has become infractions. View of this, the present petition is disposed of. The earlier interim order granted to the petitioner dated 20/03/2026 is hereby vacated, and the no kept with the case. With the above observation, the present AB stands disposed. Your AB stands disposed.
Much obliged.
36, what is the position?
Yes, my earlier one report was called for, my lord, regarding pendency of any case, my lord, against the petitioner. That report, my lord, not yet received.
But they were not on interim. I think.
Yes.
First order was, the initial order was passed on 6/4.
You know, maybe day after tomorrow, I can get it. The report.
And represented the petitioner on call. Heard Mr. P. Botku, the petitioner PP appearing on behalf of it. And it is submitted by Mr. Botku that till they have not received the report from the concerned police. In view of this, they did not prepare. When is the court? When is the key time? 30, 20. Yes. Very good.
I was protected matter on 25/2/26 matter.
Petitioner is in interim, my lord.
Interim.
Appeared before the IO, my lord.
I appeared before the IO.
In this case, my lord,
I cooperated with the my lord investigation.
IO has submitted that yes, after obtaining interim protection, he appeared before the IO, but IO has asked him to produce his bank passbook, but he has not my lord, submitted the bank passbook. That is the note of the IO, my lord. The present petitioner. My lord, initially allegation against the present petitioner is that, my lord, in the FIR is that one, the mobile of the informant was stolen by someone. Thereafter, my lord, total amount of rupees 2,94,993 rupees was, my lord, their transaction from 23/11/25 to 26/11/25, my lord, to different accounts. And during investigation, it comes to light that total more than 40 to 50 transactions, my lord, from the, my lord, bank account of the present of the informant, and from in the bank account of the present petitioner, an amount of rupees 5,000 deposited on 26/11/25. Thereafter, he was granted interim protection, and my lord, therefore, IO has asked him to, my lord, submit his. Yes.
In fact, my lord, the passbook, my lord, I have annexed it, my lord, in the petition itself, my lord. Page 17, my lord. If required, my lord, I will.
Required, then you can.
My lord, I'll submit the original one.
In this, my lord, other in this only not only the mobile number was stolen, but how he all these accused has collected his, my lord, UPI ID. Thereafter, my lord, from his mobile number, all these 50-40 transactions. So it seems that, my lord, a gang is involved in committing this type of offense. And thereafter, my lord,
His plea is most probably the present petitioner's plea is that he is not aware as to how the 5,000 rupees was
my
sent. Is
he
lucky.
is a member of the gang. Well, ultimately, he will
Member of the gang,
receive-
can I get submission?
That is the from the investigation, my lord, not of the IO. Otherwise,
If required, my lord, I'll submit the original. That will reflect in the order.
Hard Mr. And get on it. Keyboard put it with a pen. Submitted by Mr. That percent of statement 50296. He already appeared before the I cooperated in the investigation, and his statement is also recorded in section 180 PX. And Dr. Peters predictions to be involved that how he is still ready and willing to extend his cooperation if needed during investigation. Mr. Court United Scientific that investigation is still under process, and process, however, the present petitioner has appeared before the IO and his statement is recorded. However, the note of the IO, it is seen that he has not produced the passbook which was asked to produce by the IO during his interrogation. Next, considering this submission made by learning counsel, materials available in this code is of opinion that constitute interrogation may not be necessary for the purpose of investigation. However, the petitioner is hereby directed to cooperate with the IO and to produce the relevant documents if required for the purpose of investigation. In view of this, however, the order of interim bail dated 25/02/2026 is hereby made absolute with same terms.
I am obliged, deeply obliged.
May I appreciate your lordship, my lord. My lord, I take your lordship, page 10 is the FIR, my lord. My lord, may I read, my lord?
Yes.
It is respectively submitted that on 4/11/25, my son, Durgacharan Gwala, aged about 41 years, catching fish in a nearby fishery located near our house. The fishery is owned by the accused Saurav Das, and on noticing my son fishing, there the accused person Saurav Das, Ranjit Das, and along with 5-6 other unidentified persons chased my son. Out of fear, my son ran away and hid somewhere. This information was conveyed to me by the above named accused person, who also handed over to me a gamusa belonging to my son. I and my family member immediately started searching my son, but could not find him. On 6/11/25, my lord, after that is after 2 days, at 9 a.m., I found the dead body of my son on the riverside, which is very close to the accused person's fishery. Upon reaching the spot, I noticed the visible injuries on the body and one eye was missing. Well, accordingly, a case under 103 was registered. My lord, several person, my lord, one Ranjit Das came, who is named in the FIR, he approached before your lordship, and your lordship given him the liberty of the pre-arrest bail on 20th of the February 2026. Page 13 is the impugn order. Then thereafter, my lord, I am before your lordship for pre-arrest bail. My name is not in the FIR, my lord. Case is not yet charged sheeted till today, my lord. And it is a clear case of drowning in the river, my lord. I am no way connected, my lord, but police is searching me. That's why I am before your lordship. I have annexed the order of the court below also. The learned session judge has rejected my prayer, my lord, considering it is a case of murder. And there is also intimation that there are materials
Yes, my lord, case diary received, my lord. Here, my lord, incident occurred on 4/11/25.
Yes, dead body found on
Uh,
6/11.
Yeah. Then dead body found on 6/11/25 at around 9 a.m. and FIR lodged on the next day, 7/11/25. And here in the case diary, my lord, I have final opinion regarding cause of death I have received, my lord. As per the final opinion, after correlating the findings of postmortem examination and chemical examiner's report, I do hereby opine that death was due to antemortem drowning. Drowning. My lord, your lordship may kindly, I would like to point out page 16 of the petition, that is the Honorable Trial Court's, my lord, rejection order, my lord. Why these accused persons were, because on that day, particular day, disease was, in fact, my lord, fishing in the fishery of the present one of the accused, Saurabh Das. Thereafter, while all these accused persons chased the disease, he, on that day, particular day, fled away from that place, and thereafter, after 2 days, his dead body was recovered. So, my lord, those accused persons were at that point of time strong suspect of committing murder of these accused persons, my lord. In the trial court's, my lord, rejection order, your lordship, page 16.
28/1/26, madam. I have submitted, madam.
One point I would just like to point out. Last my lord, line, which is very near to the fishery of the accused, and reaching there, the complainant seen that there is spot of injury on the dead body and not having one eye. That is the, my lord, while rejecting the trial court bail application of the petitioner. Regarding that aspect, my lord, I have also gone through the PM report regarding any that regarding not having one eye, my lord. That is the but here, my lord, both eyes are bulging out, mouth open. That is the, my lord, in the PM report. So thereafter, my lord, I tried to find out the meaning of bulging out, my lord. It may indicate a condition where the eyes actually stick out, often seen in disorders like Graves' disease, thyroid problem, infection, tumors. So it is not a fact that one eye was, my lord, not there. Yeah,
Missing.
Missing, my lord. My lord,
But I will cooperate, my lord. Any condition.
Till now, my lord, otherwise there is no direct material against the present accused person. Cause of death also, my lord,
Antemortem.
final opinion
Drowning.
already received, my lord. And investigation is still going on, my lord, regarding other aspects.
1 year is over, my lord.
At that point of time, they were strong suspect because, well, on the next day of the incident, after today, dead body recovered, and that body was also recovered near the fishery of those accused persons. And in fact, on that particular day, they chased the accused and they handed over the gamusa used by the deceased to the informant mother of the, my lord, deceased. And earlier also there is dispute for, my lord, catching fishery in that fishery between the accused person. So at that point of time, they are the strong suspect.
But
Regarding, although, my lord, final opinion report received regarding there is, if there is any more any involvement of they are in the accused person, regarding that aspect, investigation will go.
But moreover, handover.
But
Gamusa was handed over by the person he has been
at
granted
this
bail.
stage, my lord, there is no
Yes,
direct material against the accused.
Yes. Learned additional PP appeal. In the court. They have not committed any violation.
Yeah.
It is like that the purpose which saw him when it's the opponent of the boy fled away. Blinded. This petition is no way. They fail by the present by this court. Considering the case, the same this prayer may also be considered. The petition is still ready and waiting to extend his cooperation in the further investigation case. It is still going. Uh, so far as the investigation is concerned, and the post-mortem report, the death was caused due to antemortem drowning, and there is no other injury found. And one eye was found to be missing at the time of recovery. But as per the PM report, both the eyes are found to be bulging out, and there is no report of missing of any eye of the. There is no such direct evidence against the present petition, but case is still under investigation. Next, explain this. Is vis-a-vis the court and the date of opinion extent, which may not be necessary in the present case. For the okay, you'll be under interim protection. There will be some conditions.
But the CGM silcher kachar.
No, this is satisfaction to the IO. It is a AB, isn't it?
AB money. Oh, I'm sorry. Yes, sir. AB, I'm sorry.
So there will be some conditions about by
Yes, yes, I will carry out, man. I will carry out.
because case is still under investigation.
Sure, I will put action cooper. Need determination. My lord, with apology, but I have got two other matter. I will not be able to attend because counting will go on. I am one of the candidates, that's why I have to remain present.
Oh, acha, so you're counting in there,
yes.
today? Yes.
Dispose of mail.
Yes, it is disposed. It is. Another matter you have today.
Two matters, brother. Any other date may fix, I shall be there.
Which item number you just tell us?
14 and 15.
In the both the matters, you are for the respondent.
Yes, I am the respondent number 2, my lord. My friend is there on behalf of state or some.
As you have already entered into appearance, your presence.
Yes, I have appeared, but I
Mr.
filed an
Doctor
objection.
was already there. Could have informed him earlier, na? उसी को लिख. And anyone ask doctor को अपन बात में 14 and 15 mark. In item number 14 and 15, you are there. So Mr. Biswas is saying that counting is going on, so he prayed for an adjournment. Do you have any objection?
No.
Objection. Yeah, that's it. Respondent number 2, Mr. S. Yes, do you want any fixed date here?
No, my lord, as per your lordship, any day.
But they have is there any interim was operating?
No more, no interim order is there.
So for their favor?
No interim order is there. Case charge sheet, they have challenged the charge sheet. Both the cases.
No, charge sheet may be there, but there may be interim. 14 and 15 out of same. 14 and 15 out of same charge sheet FIR or different
There are two separate cases.
Two separate cases.
Scan copy of TCR received in both tests.
Scan copy of the receipt.
In the trial court before. But no interim is operating.
No interim is there.
Is not.
There are
Copy we have already received, na? Totally was scan copy of the TCR has already been received. That is the detail. Can you tell Mr. Goswami where is the next date? As per the scan copy? Or not up to date? 1/3/13.
Right. Both may be same day, madam.
Both are on the same day on 30. Which going to be available?
financial bank, finance bank.
Entire amount.
Northeast Small Financial Bank.
Lord.
So he was the manager there or what?
No, Lord. Resource person.
Resource person, source person. Acha.
In pursuance to a contempt petition filed before the Honorable High Court, Honorable High Court has directed to pay that amount mentioned in the FIR, and thereafter, those amounts were deposited. The allegation of the informant complainant is that without being, by using his credential, the accused person, one Sanjay Kumar Sarkar, he opened the bank account in collusion with the bank officials, some of the bank officials, and thereafter entire amount deposited in that account, and thereafter from that account the one Sanjay Kumar Sarkar, who is in fact authorized by the informant earlier to proceed with the case, but he was not later on being by using his credential in a fraudulent manner, by using his credential, in his name, bank account was open, and thereafter, while after depositing those amount, some amount he fixed deposited in his name, and some amount, he in fact, withdrawn, and he also, some amount he transferred to SDFC Bank, total amount deposited in pursuance to the Honorable High Court, more than 1 crore, 1 crore 61 lakh 10,097. And out of which, he fixed deposited an amount of rupees 75 lakhs in fixed deposited, and thereafter one RD of rupees 18 lakh 99,478 in the name of the accused Sanjay Kumar Sarkar, and 1 lakh 5,000 and rupees 5 lakhs cash withdrawal on 2 dates, and thereafter an amount of rupees 60 lakh deposited by Sanjay Kumar Sarkar in HDFC Bank, Adabari. And during investigation, IO has hold those amounts of rupees 60 lakhs in HDFC Bank and other accounts also freezed. So an amount, the withdrawal amount, probably those amounts misappropriated, and other amounts already now on hold, other amounts. His statement is here, he being the resource person, his duty is to verify the credential of the customer, but without verifying the credential of the customers, without proper verification, without visiting the customer, he along with the, as per the instruction of the informant, in connivance with the in collusion with the other bank official, he opened the way. He is the resource person. His statement, yellow statement. Before obtaining bail also he appeared. Now after obtaining bail, he's
before obtaining means earlier stage.
Earlier also he's he appeared.
I have to make something.
Yes, yes. Yes.
Made this. The modus operandi was like this, Lord. The main mastermind was Mr. Sanjay Sarkar. Lord, he was authorized by the informant to file a case against the GST department, Lord. In fact, I had pursued that case. There was a direction by your lordships for refund of the money. Though the direction was not complied, we filed a contempt. And pursuant to contempt order, my lord, that amount was directed to be refunded. Now, what happened, my lord? The amount was to be refunded in the name of the firm Sainath Trader, whose proprietor was Sanjay Kumar. What this gentleman did, my lord, he knew that this amount is going to be refunded. So what he did, he already had this and in his own account in that same bank, Northeast Finance. what he did, since he had good relations, my lord, he opened an account in the name of the same firm, Sinat Trader. And when the refund money was there, my lord, he collected being authorized and he deposited that amount in the account opened by him without authority. And where the involvement of the accused person comes, my lords, what the bank does, they authorize this gentleman to go and verify the account. Now, his case is that because of certain reasons, I did not do my duty properly. That does not absolve him of. Because his identification of Sanjay Sarkar as the proprietor of Saina Trader, who is already having an account in the bank, who is well known, look, this is the deceptive part that has been played. And the criminal liability is not absolved, my lord, if he is taken out of the bank or he has been transferred. The culpability does not only relate to the date on which this amount was withdrawn. The culpability relates to the date, my lord, on which he was identified and this account was open. Because one day or the other it has to happen because you have already done your job. It's not a small thing, my lord. My lord, it is like I am having an account, somebody opens in my name and say the transaction come after 2 years. Will that person not be involved, my lord? My lord, this is my case, my lord. In connivances, Lord, manager and all may be involved, but this person has main responsibility. Lord, he cannot be absolved by that, saying that no, I have neglected my duty. Lord, he is an employee of that bank. He knows that that gentleman is already having a bank account. How you can say that this is a proprietor of that? Where you get that PAN card? Where you, Lord, had it been a one-off account, whether he was not at all connected, my lord, this could be a probability.
Got the PAN card in the sense that all the credentials were with
Yes,
the
yes,
other.
that is stated in the
those-
offer itself,
Yeah,
Lordship.
there is no dispute about the
Yes,
authenticity or genuineness of these gross credentials because
using
those
the credentials.
those are with Sanjay Sakar. He was there, but
No,
while
my lord,
verifying those things,
my lord, that he can't be, my lord. He cannot be the proprietor. That is the mischief that has been played, my lord. How he becomes the proprietor of Sinat Trader, my lord?
but he was authorized.
Authorized.
No, he was authorized to file a case writ petition, not for opening of the account. That is the, my lord, mischief. Lord, there has to be a, if the proprietor authorizes a my lord, employee to file a case, there is an authority letter to given to that effect.
Yes.
Not for opening of account, there was no authority. Let the petitioner or not the investigating author show that there was an authority.
Proceed with that.
Not with opening of that account, my lord. That is the mischief that has been placed. Only because he has played the mischief saying that I am the authorized representative. Authorized representative for what? For filing the case, for pursuing the matter with the department before the High Court, not for opening a false account, my lord. Therefore, my lord, this gentleman has committed, my lord, criminal offense, my lord. He cannot be lightly, my lord, taken. Then who knows, my lord, this kind of activities would continue. But I am the sufferer. And 1 crore 60 lakhs has come, my lord. I have not got a single pie. And I have been fighting this case 2016, my lord. Lord, just imagine. In fact, I had made a submission before the High Court that I am a heart patient. I need over regular checkup. Considering this, my lord, there was urgent hearing of the petition. Now, when it comes, my lord, it goes this way. Now he's trying to saying that as per the direction of the branch manager, he has done.
But Lordship, I have already cooperated with the investigation.
Yes, my lord.
Still ready to cooperate, Lordship,
No,
if you're required.
matter is not of cooperation, my lord. He says he is on the instruction of the branch manager. You will say that you kill somebody, you will kill. You can commit forgery like that. This can't be done, my lord. That is my system.
Hey, Potakur, what is the note of any other note of IO regarding his cooperation or any other note on the IO?
Yes, I will.
My lord will see the main accused is still, my lord, is not been traceable. There is no action has been taken if he says that against the branch manager and he is feeling running out. But that is how the responsibility has been discharged. The banking business is relying upon trust, my lord. One is breaks down, my lord, everything goes. Game plan is simple, my lord. If he is, my lord, protected, the manager would come and then the main accused will come.
Manager has already resigned from the bank, lordship. It's by instruction.
No, that I have seen. This is the note of the IO that he appeared and to record interrogation is there. Apart from is there any specific note from the IO regarding that file? Because his entire case is, you now see, based on the fact that obviously he opened the account on the as per instructions of the bank branch manager, and he did not go for any other verification as per the as per the direction of the bank branch manager. He put his signature in some of the documents on the basis of which and the account was.
Statement also full of because statement.
He said it that
He has stated that he has not verified, even not visited the complaint on the basis the branch manager has provided him all the documents after making his signature of the branch manager. So on being trusted by the branch manager, that documents were already signature made by the branch manager. So thereafter he has not looked into anything other, and not also personally has not verified. And on the basis of that, because branch manager has already made his signature, so on that basis he has opened that.
Yes, that is his submission.
Admittedly, my lord, he admits that he has committed this case, forgery.
Admittedly, he has not.
Now what do you say on the basis, this statement, whether any other custodial interrogation will be required? That's what I'm saying. Because no time finding and not finding anything.
Lord,
And
if
this
the
is the
lordship
simple
permit,
case
lord,
that only added with the trust with the bank branch manager, he did this without going for proper verification. That is his submission, and the statement is also there.
In that respect, there are materials against the present accused. And regarding further custodial interrogation, those amounts if which were already deposited in person to the order of the Honorable High Court, most of the some amounts only he has written, but other amounts during investigation already on hold.
On hold, yes.
That too by the name accused, lordship, Sanjay Sarkar.
5 lakhs and one is 1,05,000 that was withdrawn by on two different days. Regarding those, only the main accused person, he can only answer regarding that. Regarding that, there is no note whether those amounts were recovered from the accused Sanjay Kumar Sarkar.
but so far as
Regarding that, there is
so far as our information is concerned, my lord, only 60 lakhs has been there in account, 90 odd lakhs has been taken away. And what he does, my lord, 50,000, 1 lakh rupees, he is still depositing in our account, saying that there is a settlement going on. Now, this is the main. My lord, lordship's custodial interrogation is required because to find out the connivance between the parties, my lords. My lord, he is out. Bank manager, as my learned friend says, he is gone. So nobody is taking responsibility for that, my lord.
Yes.
Every transaction was done by the authorized person of the informant lord, which is submitted by my learned friend lordship for the steps. He has done nothing, lordship. The
No,
present
I have not said that. I have authorized.
state.
He's not authorized on
What
that.
I'm saying that he was not authorized to open any account in the name of
That might be
the
lordship,
company.
but it was done
He
by the
was
Sanjay Sarkar.
authorized only to institute a
That-
case
that
and
is
wherein all the credentials were with him.
That may be or may not be, Lord. I can say, Lordship, that aspect, Lord, because he opened the accounts with credentials of the informant, Lord.
Credentials of the informant.
Lordship. And each and every transaction was done by that person, Lordship, not by me.
My lord, my
Not a
case is
single transaction was done
matter
by
of
me.
transaction does not come because the entire mischief has been done while opening. The transaction would not wipe out the connivance, my lords. You have opened it, very well gone.
That
Now
was admitted, Lord. The
transaction would
petitioner
be there,
also
may not be there.
stated
Still
it.
it is
I
an offense.
also, Lord. Your Lordship, what is the necessity of custodial interrogation, Lord? That is the fact, Lord.
But the connection between branch manager, accused, and the Sanjay Sarkar, my lord. Still they have not been arrested.
Mr. P.K. Gugul, the learned counsel for the petition, also heard Mr. P. Bott, the learned additional PP, appearing on behalf of state respondent, and Mr. R. Dubey, the learned counsel, appearing for the respondent of public. This is an application under section so and so, connection with so and so. CD received, whereas received. It is submitted by Mr. Gugul, the learned counsel, that he already appeared before the High Court in 2 occasions, wherein his statement is recorded by the High Court, and thus he extended his cooperation in the investigation of this case. He further submitted that during the period he was working as a source officer, the bank, source officer of the bank, and and the bank account was opened in the name of China Traders only after verification of the credentials which were produced in the name of the informant. However, it is a fact that he did not go for proper verification of the documents, as he had trust on the branch manager, and as per the advice of the instructions of the branch manager, he put his signature on the opening account after the signature put by the branch manager. He was an bona fide belief that the account which was opened, the name of the informant of the company was verified by the branch manager, and the only basis of which he did not go for further verification and put his signatures. However, prior to the order dated 26/02/2026, he appeared before the High on receipt of the notice, extended his cooperation, and after the order of pre-arrest bail, interim pre-arrest bail, he again appeared and cooperated in the investigation of this case. He had no mala fide intentional act. Accordingly, Mr. Gogoi submitted that the present petitioner is no way involved in any connivance with the other bank officials in opening the account, other bank officials, or the accused Sanjay Sarkar, under who opened the bank account in the name of the informant and in the name of the company of the informant. Next, Mr. Botako, the learned additional people submitted in this regard that after obtaining the order of interim pre-arrest bail, he appeared before the IO and cooperated in the investigation, and his statement is also recorded by the IO. But it is seen from the his diary. But further, he submitted that the co-accused Sanjay Sarkar was only provided with all the credentials of the informant, only to institute a writ petition, which he had misused and opened an account in the name of China Trader using the credentials of the informant. Some of the account has already been transferred in his account, which is maintained in HDFC Bank, and some of the account has already been withdrawn by said Sanjay Sarkar. However, after the institution of the order, the other bank accounts, etc., were on hold, and the accounts of said Sanjay Sarkar is now freezed by the order of. He further submitted that the present petition, there is no transfer of account in the name of the present petition, but he is involved in the offense as he was supposed to being the source officer. Being the source officer, he was supposed to do all the verification before opening an account in the name of the company of the Mr. Waterford further submitted that his custody interrogation may be required to unearth some more facts of this. Next part. Mr. Rubin, the learned counsel appearing for the informant, respondent number 2, submitted in this regard. Thus, there was a connivance of the bank officials, including the present petitioner and the main accused Sanjay Sarkar, under which an account was opened in the name of the company of the informant. He further submitted that all the credentials were provided to the accused Sanjay Sarkar only to institute an a writ petition, wherein the subsequently one contempt was also filed, but it was not for opening any account in the name of the company, and behind the back of the informant, the account was opened in the name of the company only with the connivance of the bank officials, including the president. Though some of the accounts were now freezed as per the direction of the court, but the main accused Sanjay Sarkar had already misappropriated some amount of money, uh, which has already been withdrawn by him. Accordingly, Mr. Dubey submitted that to unearth some more facts of the case and also to investigate in regards to the connivance of the bank officials along with the present petition, the custodial interrogation may be required. Accordingly, he raised objection in granting pre-arrest bail to the present petition. Rehearing the submission made by the counsel for both sides, I have also read the case record and the case diary along with the annexures. It's an admitted fact that during the time of opening of the account, the present petitioner was working as a source person to the bank, and on the basis of the verification of the source person, the account was opened in the name of the company of the account. But in the same time, it is also seen that all the credentials were with the co-accused Sanjay Sarkar, who produced the documents before the bank authority at the time of opening the bank account. However, from the submission made by an counsel for the informant, it is seen that all the credentials were provided to the co-accused Sanjay Sarkar only to open the bank account, or only to institute a writ petition, and not for opening any bank account in the back of the informant. But from the statement made by the accused before the IO and from the note of the IO also, it is seen that there was no proper verification of the identity of, no proper verification at the time of opening the account. But is the note of the IO that present petitioner had placed his case before the IO that he put his signature on the verification note only after the signature put by the branch manager. And in the same time, as per instructions of the branch manager, he prepared the verification. However, the case is still under investigation and it is to be investigated, is to be investigated as to who and how those, how the account was opened without being authorized by the Sanjay Sakat, and as to whether there is any connivance of the present petitioner in the it is said. However, considering all the matters in the case record, no comma, note of the I, and cooperation already extended by the present petition, this court is of opinion that custodial interrogation may not be necessary for the purpose of investigation. However, the petitioner will appear before the I every fortnightly to extend his cooperation if required or as per direction of the I. With the observation, the order of interim period is bail granted to the present petition dated 26/02/2026 is hereby made absolute with same terms and conditions and with a direction to extend his cooperation as directed.
Deeply obliged, Lordship.
It is also, little correction, Lord. Your Lordship has indicated as company, it's a proprietorship form, but wherever.
Proprietorship form.
Yes, yes.
Proprietorship form.
Yes,
Will
deeply
mention.
obliged.
This matter is between the husband and wife. The relation between them is for a couple of years not good. Now she's on interim bail. Lord, your lordship's called for the scanned copy of the TCR. It has come. Regarding GD entry 48, my lord, I do not know whether it has come or not. Nonetheless, my lord, since the custodial investigation is long over, your lordship can see whether even, my lord, at this stage also your lordship can consider to make the bail application absolute. Because, my lord, she is not a, my lord, that way, she did not have any antecedent of criminal nature. Criminality is not there at all. So therefore, if your lordship look at the charge sheet, and the statement given by her and the statement given in the GD entry, she has accepted the position that she had to protect her by using that kitchen knife because he went into the kitchen quarreling with her, beating to her son also. In that position to protect her, he used that. And in that way, the injury is inflicted to the person. Now, in regard to the, my lord, granting of bail, further extension of bail, my lord, the appeals court has very clearly said, your lordship is already aware on the last occasion. I took your lordship to that. Once again, my lord, I will read that there are 20 of that judgment. But under what circumstances when the custodial interrogation is over, whether under what circumstances bail can be cancelled and where her arrest is necessary, that has been explained. Your lordship may kindly come to paragraph 20 of this judgment. Has your lordship got that?
Yes.
In normal and ordinary courts, the police should always avoid arresting a person and sending him to jail if it
It
is
starts with the sentence starts with the
rather the law is otherwise. Para 20. So no, it's not para 20, Melvin. In fact, it starts with paragraph 21. This is a quotation from another judgment.
yes.
Para 21, then next page 9.
Yes.
Subpara 20.
Yes.
It starts with rather the law is otherwise. In normal and ordinary courts, the police should always avoid arresting a person and sending him to jail if it is possible for the police to complete the investigation
without his arrest, and if every kind of cooperation is provided by the accused to the investigating officer in completing the investigation. Here, my lord, investigation is all over. It is only in cases of utmost necessity, your lordship kindly see this, utmost necessity where the investigation cannot be completed without arresting the person. For instance, a person may be required for recovery of incriminating articles, for weapon of offense, or for eliciting some information, for clue as to his accomplices, or any circumstantial evidence that his arrest may be necessary. Such an arrest may also be necessary if the investigation officer concerned or officer in charge of the police station thinks that presence of the accused will be difficult to procure because of grave and serious nature of crime and the possibility of his absconding or deserving the process of fleeing from justice cannot be ruled out. Now that these things are absolutely, my lord, not there at all, because she is a poor lady living with her younger son, and my lord, the person, his husband came to his residence, my lord, to talk with the son, and my lord, the son was totally frightened because he was abusing. Then he has beat the child, he has beat the wife. Under such circumstances, this incident occurred, and in the first FIR she has given, though no investigation has been carried out in regard to that. Now, your lordship is well aware of the law that when the two FIRs in the field, the same the IO will have to investigate both the investigation. Now, here one investigation of a GDNT 48, it is in a standstill manner, they did not do anything. Now, whatever it is, my lord, I want to say that when the interim bail has been granted, and if she doesn't come within the ambit of this paragraph 20, my lord, since the bail has been granted, your lordship may make the absolute, my lord, because if your lordship has seen GDNT, I think last time I given to your lordship, once again, your lordship may see what part she has admitted. Yes. Is a out of self-defense, my lord, she had to take that reports. My lord, in second page, your lordship will find a line about 3, my lord. To save myself and my child, I got hold of the knife and attacked him to defend myself.
And which section case is registered?
This is, my lord, 1182 and 109. And my lord, it's not attract 109. In fact, my lord, if your lordship look at the charge sheet, my lord, the investigating officer has said, out of, my lord, just I'll read the line. Precise line is, during investigation, it also surfaced that there were ongoing matrimonial disputes. My lord, I'm skipping that. From the cumulative evidence collected, including witness statements, medical opinions, seizure of the weapon, offense, out of anger and without lawful justification, stabbed her husband with a sharp weapon, resulting in grievous bodily injury. Now, this is out of anger. That means, in that case, my lord, it will attract. My lord, section 122 of the BNS. My lord, this reads like this: voluntarily causing hurt or grievous hurt on provocation. Whoever voluntarily causes hurt on grieve and sudden provocation, if he neither intends nor knows himself to be likely to cause hurt for any person other than the person who gave the provocation, shall be punished with imprisonment of either description for a term. It may extend to 1 month or with fine. Now, all this, my lord, nitty-gritty of the thing, your lordship may, for the time being, it can be ignored because it's a case where a poor lady is before your lordships and she is not a hardened criminal. So therefore, keeping that idea in mind, my lord, if your lordship look at the appeals court decision, in what way, my lord, once bail is given, when it can be cancelled. And is not that such of a kind that she can flee away from justice or she can go somewhere else. A poor lady from a middle class family, your lordship can understand. And she is a school teacher, is having small baby. and how husband is torturing. And how the husband, my lord, we know by the police also. The lordship has seen one case, charge sheet has been given, other which is prior in time, they did not do anything. Now, I don't want to accuse anybody, my lord, the law is very pure and simple. In such type of cases, my lord, your lordship at this stage also can make the bail absolute. And your lordship is well aware about the, my lord, law, I mean, National Law Commission's report. When the conviction rate is less than 10%, my lord, the court has indicated that such type of indiscriminate type of arrest is not good. And the quality of arrest in India, your lordship has seen, is so poor. My lord, just their idea, the idea of the police is to arrest someone. That should not be made. Because if it is needed, okay, you do it. Is it a case, my lord, the arrest is when the custodial investigation is all over?
Now she has shown absconder in the charge sheet?
No, no, my lord.
No, no, no.
You are not shown as
No, no.
After obtaining interim protection, he appeared, thereafter charge sheet submitted. That note is there, man.
All sorts of
Hard
cooperation is
statement
there. I think my learned friend will agree with me.
My lord, scan copy of TCR received, my lord. Here, charge sheet submitted only against petitioner number 1. That is the wife of the informant. She is the wife of the informant. And my lord, under section 1182 and 109, injury report is also there. Grievous injury, my lord, neck, left side of the neck, my lord, which supports the contents of the affair. Otherwise, my lord, both the petitioner and the informant are husband and wife. The dispute going on since long between them, my lord. One divorce case is also pending between them. One PRC case is also pending. Considering
Who is the petitioner number 2 in fact?
he's
the son?
Two is the
mother of the
mother, my
petitioner
lord.
number
I
1.
think the last occasion when order is passed, so far she is concerned, my lord, she has been released.
Against her, my lord, charge sheet not submitted. Only against the petitioner.
Order is already there.
The order passed with it. He has been. Nine. Last order to nine.
Injury is grievous, man. Injury report is there. And offensive.
Is there any order in regards to this respondent number, petitioner number 2?
Yes, the
Order is
last occasion when order is passed. I think it's the order. You are right.
So why then interim bail was actually made absolute? If she is not charged.
No,
Number 2 is not charged sheeted.
No,
No, I think one order is
after
passed
obtaining
with-
interim, my lord, she appeared before the IO, my lord. Thereafter, charge sheet probably submitted. So IO has in his note stated that after obtaining interim protection, my lord, he appeared before the.
No, I'm not on that. 2 petitioners are there.
Yes,
One is the wife and one is the mother.
Yes, madam.
So you are saying that petitioner number 2, that is one Tamisha Chakraborty, who is the mother,
Yes,
against her, charge sheet is not filed.
not.
So
Against petitioner number 2, no charge sheet.
no
submitted.
charge sheet. That's why I'm just asking there in the order, last order, that is on 33.
Yes.
03, in view of the aforesaid development, the interim bail granted to the petitioner number 2, namely Tamisha Chakraborty, is hereby made absolute. Why? There is no question of making the bail absolute. It may be disposed of or whatever. It has already been made. I will not going to see this one. Okay. Heard Mr. S. Dutta, the learned senior advocate. Counsel assisted by MS. You are assisting or Musahari was there, na?
Musahari.
M. Musahari, na?
S. Musahari.
S. Assisted by MS S. Musahari. No, you want your name to be.
No, that's okay.
Because S. Dutta did double. Anyway, S. Musahari, learned counsel for the petitioner, also heard Mr. P. Potakur, learned additional PP, appearing on behalf of the state. Scan copy of the TCR has already been received. Parents TCR. Next one. It is submitted by Mr. Doctor that after obtaining the order of interim pre-arrest bail granted to the petitioner number 1, dated 24/07/25, she already appeared before the IO cooperated in investigation, and her statement was also recorded during the investigation of this case. A further submitted it was a dispute between the husband and wife, where the wife of the petitioner had to take such steps when the informant of the husband of the petitioner came here and tried to assault and her son and herself. Was only to save herself, she had to take such steps wherein the informant sustained some injuries, but there was no such intention of causing any hurt to the informant. But due to this part of the moment, this had happened. She also immediately lodged an FIR intimating the entire facts of the case before the police station, but that was not registered, and subsequently the case subsequently the case filed by her husband of the informant was registered and charged under section 1182 and 109. Oh, yes. Mr. Doctor further submitted that in case of sorry, Mr. Doctor further relied on a decision of Honorable Apex Court passed on it was 09/02/2026. Date was this criminal
That is, this order was passed on 9/2/2026.
9/2/2023.
My lord.
9/2/2026. In case of Sumit versus State of UP and another arising out of SLP criminal 1536 of 2026, and basically emphasized on para 21 and para
20.
20 is not the para actually.
It is not para actually. It is the, my lord, from decision it has been quoted. Quoting from the Delhi High Court's decision.
D para 21, wherein quoting was made, wherein an emphasis has been made from a case of with para 21, wherein case of Delhi High Court versus CBI reported in 2004, SCC Online Delhi 53, 53, and something like to no. Planet Huh? Huh? and uh, and uh, special emphasis has been given to the following in the following para. Cliplet 20, invert form to 20 di form, itu mark word. Inverted form to 20, invert form to di form. If itu para. Page number 9. Citing the above reference is submitted by Mr. Ilan and Senior Advocate that considering the nature of the offense, it is seen that the custodial derogation or custodial detention may not be required for the present petition, who extended her full cooperation during the investigation of the case and is still ready and willing to appear before the learned trial court below in each and every day to fix that court if her interim bail is made absent. There is no necessity of she has no criminal background or what had happened in the day and the entire incident had happened at this part of the moment and is ready to cooperate with the investigation. Cooperate and ready to appear before the learned trial court below and to extend her cooperation. All of to Milan Island. No? Next one, Mr. Board, learned additional PP submitted in that the present accused petitioner is not shown as an absconder. And from the available materials, it is seen that she extended her cooperation during the investigation of this case. However, from the injury report, it is seen that a victim, public informant, sustained previous injury on his neck portion, and accordingly, the case is charge sheeted under section 1182/109 of BNS. Mr. Botnaper, however, submitted that the cooperation during the investigation was seen, and after obtaining the order of interim pre-arrest bail also, she appeared and extended her cooperation. Considering the submission made by learned counsel for both sides, materials available in the case diary, and also considering the conduct of the accused petitioner, who initially appeared before the High Court, cooperated in the investigation, I find that her custodial detention may not be required, and according to the order of interim pre-arrest bail dated 24/07/2025 is hereby made with a direction to the present petitioner to appear before the learned trial court below with an application for regular bail, which may be considered in. Okay, your maid is made absolute and you appear before the learned trial court below with a regular application for regular bail, sorry.
Possibly she has already appeared.
Achha. It is disposed of.
Well, much obliged.
My pleasure, Lord.
CDO.
Here at the outmost logic, first I'd like to submit that we prayed that we'll file an affidavit, but the instruction goes that affidavit is not required to be filed. Not required to be filed, because what has happened, Lordship, here first when we filed this petition, we were of the information that there was no case registered against him. Subsequently, Lordship was pleased to call for a status report. In which status report? A report came that an FIR has been lodged against him. FIR has been lodged under 3.5, 351 subclause 3 and 69 of BNS. Now, your Lordship may kindly see that I have already appeared before DI on 7/3/2026. And subsequently, Lordship, we have entered into a compromise with the informant, and whereby the instruction goes that he has now agreed to marry this lady Lipika Saikia. And then instruction further goes that Lipi Saikia She has given a statement before the IO that she is not willing to pursue with this FIR. I do not know. That is what I'm speaking is on my instruction. Rest my brother will know what is in the case there that is not known to me. Otherwise, Lordship will kindly see, if your Lordship looks into the FIR, Lordship will kindly see that neither 69 nor 351 subclause 3 is attracted against me. 69 says false promise of marriage.
No, where from you're saying you have not annexed the,
No, but I have obtained a copy of the FIR, Lordship. I have obtained one copy of the FIR
after registration of the
after registration, Lordship. Certified copy of the FIR. Now there I have read the FIR, Lordship will kindly see it's a very lengthy FIR, Lordship. Something against me, against my sister, my entire family members. My sister and my other family members are not before your Lordship. Only I am before the Lordship. Now here, Lordship, it is an admitted fact that she knows, the informant knows that I am already married. So if the informant knows that I am already married, so therefore there doesn't arise any false promise of marrying. 69 will not go. And 351 subclause 3 says giving, threatening to the extent of causing death, which is also not there. Lordship, this petitioner, there is no other, any other criminal antecedent, Lordship. He is a boy who is doing a small business, a petty business, he was living his life. But thereafter, they entered into an they entered into an agreement, Lordship, which was prior to registration of the FIR. But in that agreement, there are certain things from which I said that no, I cannot go by this agreement. And only because I said that I cannot go by this agreement, this FIR has been registered against. That's what is there in the case diary. Other case.
Yes.
Otherwise, I have already appeared, Lord.
Yes, case diary received, my lord.
I have appeared.
Yes, my lord, victim, my lord, knows that already the present petitioner is already, my lord, married. But the problem is that the petitioner stated that, my lord, the one divorce proceeding is going on between his earlier, my lord, ex-wife. So, my lord, he established, my lord, love relation with the present victim, my lord. Thereafter also established physical relation, my lord. Thereafter she became pregnant. And now, my lord, he stated that he will not marry the victim, my lord. Here in this case,
you will not marry the victim.
yes.
No.
Later on, my lord, some development, maybe, my lord, he stated that those things are not there regarding the present status.
There in the statement of the informant.
I will point out, your lordship, regarding the statement of the informant, yes, last portion, my lord, he stated, কিন্তু মোৰ শাৰীৰিক অৱস্থা ভাল নহয় আৰু প্ৰেগনেন্সিত কমপ্লিকেচি আছে, গতিকে মই গোচৰটো চলাব বিচৰা নাই, মই দৌৰাদৌৰি কৰি থাকিব পৰা অৱস্থাত নাই, মই বাচ্চাটো বিচাৰো. She refused other medical examination, my lord, regarding. Your lordship may kindly peruse our statement and statement of the present petitioner's ex-wife and accused.
Is there any development regarding their or compromise is there?
Regarding
Wherein-
that aspect, I do not find anything in the CD, my lord, regarding compromise.
Now her earlier wife and he, both of them has decided.
She knows
to
he is a married man, but my lord,
as per my instruction, Lordship, with the earlier wife, they have mutually decided to divorce. And only because of the informant's relationship. Otherwise, 69 is not attracted, Lordship. 69 is very clear. 69, Lordship, from the very inception, there has to be an intention of. I like my law point of view. 69 says, Lordship, that from the very inception, the promise should be with an intention to deceive. But I made no such promise, Lordship. She knows very well that I am a married person. So therefore, the question of marrying her.
You are a married person, but you promised that you will marry her
No,
after
Lordship.
giving divorce to your wife.
That
That's
was
why on that assurance only.
that
she was
development
with you.
came subsequently. That this is the agreement, Lordship.
No.
Subsequently, it came up. And
What
that is why when my wife came to know that I have a relationship with another girl, so she has agreed to divorce me. But earlier,
So
when
now
when
you're
I
saying that 69 is there, 69, what 69 say?
69
He
is
was under impression that you're going to marry her after divorcing
No, no.
your wife.
no.
Maybe second wife, second marriage, third marriage, we are not from there.
Lordship, may I just make the point clear, Lordship? When I met her for the first time, Lordship, I met her along with my children. So she knows that I am married. So when I met her for the first time, there was no question of promising her to marry. It was only a cordial relationship. Subsequently, relationship developed. Subsequently, when the relationship developed, when my wife came to know about this relationship, my wife
When
said,
the relationship develop, that is understood. In the first day, you
The
and
first day,
and as per 183 statement of the victim, also she agrees that he was a married man.
then
She knows.
yes.
But now the question is that, in spite of your marriage with some another lady, you promise her that I'm going to marry you after divorcing the first wife or the earlier wife.
Because why this happened, Lordship will kindly see. Because on the first day when I met her with my daughter, at that point of time only my divorce petition along with my earlier wife was going on. So the relationship was strained. From the very beginning, before meeting her, the relationship was strained. So she knew about it. Anyway.
She knew about it. That is not.
Anyway, Lordship. I participated in the investigation, Lordship. I appeared before the IO on 7/3/2026, and thereafter, Lordship, the IO never called me. And if the IO call me, I am ready to cooperate, Lordship. Nothing. It is not that I do not want to cooperate.
Administrative Sachi Dilan's advocate. Dilan counsel appearing for petition and also had to award the PP. Appearing on this is an application, the section so and so, section with so and so. City received, subject by Mr. Sachi that in person to the order of scope and need their occasion also, the petitioner already appeared before the high. His statement is recorded and he also extended his cooperation in the case. He further submitted that as per the recent development, the talk of compromise is going on between the parties, and the victim also not interested to proceed with the case. He further submitted that it was within the knowledge of the petitioner that the accused, it was the knowledge within the victim that the petitioner is a married man having children, and thus there is no scope of giving making any false promise of marriage to affect section 69 of the PNS, as well as there is no ingredients also to affect section 351 of the PNS. However, the petitioner has already extended his cooperation, and the process of divorce is also going on between his wife and himself, between him and his wife, and as per the compromise also after the divorce, they are ready to compromise. As per the compromise, as per the instructions of the instruction after the divorce, the petitioner is going to marry the victim. Next, accordingly, he submitted that there may not be any necessity for custodial interrogation of the present petition. However, he is ready and willing to extend his cooperation as and when it will be required. Next part, Mr. Bortland submitted that the informant of the victim brought the allegation of physical brought the allegation against the present petitioner that he had sexual relationship with her with the promise of marriage after divorcing his wife. However, from her statement, it also reveals that she is not interested to proceed with the investigate further, as she is not keeping well, and as she is not physically well due to her pregnancy. Mr. Bottom, however, submitted that the accused petitioner appeared before the and extended his cooperation after obtaining the interim protection and the interim considering this submission made by multiple sides. It's including the materials available in the case diary. This court is of opinion that custodial interrogation may not be required for the interest of the investigation. In view of this, the interim order granted to the petitioner dated 25/02/2026 is hereby made absolute with a direction to extend his operation with the IO. No, yes, no court to action has it. It hereby made absolute with the following direction. Cooperation not to take any course of action. Yes. And there will be some terms and conditions. Your bail is granted you absolute bail. There are some terms and conditions will be there. They appear before the IO. Yes, if further requirement is necessary, then you appear before the IO and this platform.
Lordship.
Otherwise, I have given you the absolute bail.
I'm developed.
He shall not intimidate my lord in any way.
Pardon?
He shall not intimidate the victim, my lord, in any way.
Shall not intimidate the victim.
In any way.
Incriminate.
Intimidate the
Intimidate.
victim.
Watch out.
Intimidate.
Yes. Okay.
Developed.
My lord, I may be excused. One submission I forgot to make. My lord, when your lordship made the bail absolute, my lord, further application there for regular bail is not necessary.
Necessary.
My
You
lord,
have to go for regular bail.
no, it's not necessary, my lord. Your lordship, can I take your lordship to that judgment, which is referred in page
We are
7?
not there. I'm saying that your absolute interim bail is we have made absolute.
Yes.
No issue. On the basis of which you have to apply a regular bail has to be there. Otherwise, how it will be?
No, my lord, the Constitution bench judgment is very clear. I'll just read a line from there.
No.
My lord, it is held that the life of duration of an anticipatory bail, but it does not normally at the time and stage when the accused is summoned by the court or when charges are framed, but can continue
Now
till
see,
the
the
end of the
question
trial.
is that when during the investigation
Yes.
period, if your bail made absolute, then definitely someone will go, you appear, your regular bail will be there.
No, I have already appeared, my lord.
No,
And
that's what I'm saying. You're regular, and if you're already appeared, then no, may not be required.
so therefore, my lord, if your lordship says that we were to file a regular application.
So you cannot remain on your anticipatory bail before the court. You cannot remain.
The law is that, my
No,
lord.
you cannot remain on anticipatory bail. You have to be
My lord,
regular
that's the
bail.
thing.
Whenever there is, suppose anticipatory is obtained from the court.
Yes.
In that case, someone will be issued, and whenever they appear, there may not be any order of bail absolute, but you will allowed to go on bail. That is the issue.
No, my lord, the thing is what happens, my lord, sometimes.
If she has already appeared, then it's okay for you. What is it necessary?
My lord, that line may not be necessary to say that I will require to file an application for regular bail.
Yes, I have already.
Because the constitution when judgment is very clear, Sushila Agarwal.
I have what I am submitted that you just go and make a application. If I already appeared,
yes,
and I have made absolutely, may not be necessary also. I'm not on that.
I'm on that only.
May not be necessary. But whatever I'm saying that if someone is on anticipatory bail, if charge sheet is supposed submitted, then he has to appear before the court after receiving summon.
Yeah,
and in that case, an order will be passed that he's already on anticipatory bail, so he's allowed to go on regular bail.
That formality is okay.
There's no other requirement.
But sometimes what happened, my lord, they reject it, saying that, my lord, heinous
Your
crime.
bail, when your bail is made absolute, no court will reject it.
In that case, it's okay.
Yes, what is 38? Yes, Mr. Ali. Not going to hear it.
My lord,
You have already appeared. On the last occasion also, Acha, on the last occasion, it is written that on behalf of respondent number 2, one Wakalafnama is filed.
Yes.
So you have already accepted. So it is over, then we can list it for admission column or what?
Well, yes, Lordship, I have filed an IA for leave application.
Huh?
This criminal appeal has been filed against Equitel, my lord. And
Leave application is there. Here to it. Now this is I criminal is what is it?
For leave.
I criminal 49/2025.
For leave.
It's a leave application.
Leave application.
And I'm going to hear today, we'll hear it. It's a leave application, so please make submission on that because it is against Equitel, na?
Lordship, yes.
I have some objections, my lord.
What kind of? No, we are not going to pass any order now. We'll be hearing. We'll hear the matter. You will get an opportunity of submission.
My lord, then I will submit, my lord.
Oh, yes, yes.
Let
Without
submit
hearing you,
objection.
you are not, because it's a leave application. It simply cannot be allowed. We have to hear it.
Written objection, I'll.
You can, obviously. Now, it was waiting for your appearance. So you have already appeared. It's okay. You will get the chance. No issue. Pardon, Mr. R. Ali Dilani.
H. Ahmed.
Oh, sorry. H. A. Ahmed Dilani, counsel for the petition. And also heard Mr. M. P.
Yes,
Goswami, M. P. Goswami Dilani, additional BP appearing on behalf of state respondent. And Mr. S. Ahmed Dilani, counsel appearing for the respondent number 2. Let the matter be accordingly listed. No, sorry, Mr. Ahmed further submitted that he needs some time to file the written objection against the present leave petition. Let the matter be accordingly listed. No. Only leave application.
Orders.
Orders column, little be an orders column.
Yes, the order.
1-3. It will be listed in order column. You make your submission, maybe oral submission will also do, or you can submit because because it is against the equity. So your criminal appeal is not yet numbered or registered. Let the petition be disposed of then. It may not be entertained, maybe.
Yes.
So we are listing it on 13.
May please, Your Lordship. Lordship, this is an IA for suspension of sentence. Lordship, previously the service report was awaited and learned PT was.
What is
Kindly see the office report, my lord. Office note, my lord. 7-4 office note.
7-4.
Lordship. The last note. No step.
Now just a second. Here on 7-4-2026, one note is there. Here it is written the stage for service of notice has not been received yet by the concerned section. So have you taken steps?
Lordship, we have taken steps and we have served the copy through the PP office because the steps are to be taken through the PP office and then it goes to the OC of the.
No seal, etc. there
For the registry.
For receiving.
First registry.
First registry, then from registry it will go to the section. No, whatever, but here the seal is also not available. Whenever the office of the public prosecutor received any notice, obviously there is a seal because it was submitted, accepted by them. But this is also no. Can you tell us when you took steps for notice?
On 13/3/26 in the main IA.
13/3.
13/3. 13th of.
Perhaps, my lord, not for the registry, my lord, because there is nothing regarding the
nothing
receiving of the steps, my lord. So
in IA criminal.
In IA criminal.
996.
996.
Notice.
So they have to.
Perhaps in the main appeal, Your Lordship, we have taken steps back in 16th of October, Your Lordship.
So what is the position of appeal now? Appeal, they have appeared?
Appeal has admitted, Your Lordship, but service report is awaited in the appeal as well.
In appeal also.
Yes.
Now, if service is suppose completed in here, then we can hear the matter and accordingly the appeal main appeal also may be heard by appointing any amicus, whatever, if required. Now, but there is no.
I have seen it, madam. Because no steps, madam, has been taken. as part of it.
And you are saying when you have taken step?
In the IA, we have taken steps on 13th of March.
Kind of like,
That is.
not here. Mr. Counsel, it is not here.
Perhaps then your lordship may allow us to take fresh steps.
Registry. They may take fresh steps through registry, man.
When you are taking, when you have taken steps, you're saying?
In the IA, we have taken steps on 13th of March, your lordship.
13th of March. Don't know. The report is also a bit. First order was passed on 27/2, when you were asked to take steps to notice. And then next order is on 16/3. Wherein also you made a submission that on 13/3 you have taken steps. Then come 20/04. So, but your office is not received.
Not received, ma'am, because I don't know whether they have directly sent it to the office. That may be a.
On what process you have taken steps?
Your lordship, we've given it to the OCO, to the PP office, your lordship. Perhaps.
But there is PP office.
Yes, your lordship. We have the receiving copy of the extra copy.
In a wrong way, ma'am. First, they have to submit to the registry. So
They have not gone in a proper direction.
Perhaps.
Whatever is direction in the to be taken by, especially in case of POXO and 376, may not be in that process. I don't know, because there is no note of the public prosecutor also receiving. While they receive the notice, anything, they used to put a seal. That is not available in the report. I mean, in the office note.
Perhaps we'll take fresh steps in the IA.
We will take a fresh steps through that process only. Okay. You are Mr.
Jake Moore, your lordship.
Jake Moore. Or Mr. Jake Moore, the applicant. And also Mr. Hicks. As per office note dated 7/04/2026, the state for service is not received by the consent section. However, it is submitted by Mr. Moore that they've already taken steps on 13/3/2026. 13/3/2026. But from the office report, it is said that there is no note about the receipt of notice by the Office of the Public Prosecutor. In view of this, the petitioner is hereby directed to take fresh steps through Office of the Registry and the Office of the Public Prosecutor as per process. And after receipt of the through OC of the concerned police station, routed to the Office of the Registry and the Public Prosecutor. You make an address to OC concerned. It will be this routed two process. That is one through the Office of the Registry and then Office of the Public Prosecutor. And then we can instruct the Public Prosecutor to take any instructions in regards to service of. Otherwise, if they have not received the notice, then instructions cannot be given. You take steps within 2-3 days because it is already late. It is of 2025, so let the process be. And if suppose any reason it returned unserved, or suppose if it is served and they did not appear, then we immediately on that day itself we can appoint an amicus.
Okay.
So you want here fixed date, or after 2 weeks will do?
The lordship may grant us a fixed date.
15th of May.
Oblige, your lordship.
My lord,
Here, this is an application for bail, my lord.
So here, as per office note, it is unserved notice has received consent section, addressee expired,
Expired.
return to sender. So addressee expired. Who was the addressee? Does the
He is
respondent
the
know?
informant, madam.
Informant.
PW1, madam.
OPW1.
He is a complaint.
So he expired.
Not.
Is there anyone to be served notice or what to do? It is a case of what? 376, no?
376.
376, my lord, here.
Whether he was, so we can serve notice to victim also.
Victim. But whether victim is, yes.
Victim is deaf and dumb, my lord.
Oh, victim is deaf and dumb.
43 years ago age. And from the statement of
Then
the
what can we do then?
My lord, they,
my lord,
anyway, my lord, as part of victim has to be heard in any way. So,
victim
or
can,
your then amicus can be appointed for
victim cannot speak, my lord.
I can understand.
victim
That's why-
or informant, whoever may be.
Amicus curie may be appointed.
In that case, better to appoint an amicus, otherwise it will be pending.
Pending.
And
Because
the
to
bail application will
represent the
consider, my lord,
victim,
because
one amicus can represent the victim.
Lots.
And if she is a deaf and dumb girl,
Deaf and
so
dumb.
may not be police.
Lot.
mentally sound, but the deaf and dumb.
But my lord, regarding the appointment, my lord, amicus has to be appointment regarding the respondent, but the respondent number 2 has expired, my lord. On behalf of whom, my lord, that
And
is,
we have
there
the,
is some technical.
the lordship can, your lordship can,
We may appoint to represent the victim only.
Victim.
Because
Yes.
informant is no more.
No.
Or we cannot search for other person who may
Also.
be the informant or next door.
Yes.
her mother
Kind
is
of
also there.
possible on the part of
No.
the.
My lord, her mother is also there.
Oh, mother is there.
Mother people through. You understand? The mother we have told you.
Let the amicus be appointed.
No.
Otherwise, it will go long.
Go on and on.
For mother, we have to again.
Again.
You have to implead her as a
Implead her.
party. That case.
Lot.
Let us see in but that manner. Part Mr. R.P. Sharma.
Oh,
The learned
my God.
senior assisted by
D dollar.
D. Dole. D. Dole, the learned counsel for the appellant applicant. And also heard Mr. M.P. Goswami, the learned additional PPA paying on behalf of the respondent. As per office note, dated as per office note dated 23/04/2026, the notice return answer to the concerned section with a note that invert comma addressee expired, return to sender. It is next point submitted by Mr. Sharma, the learned senior advocate, that the respondent number 2 was the informant of this case, and the victim of this case is an deaf and dumb girl. So she may not be in a position to represent herself. Next part, considering the submission made by Mr. Sharma and also hearing the learned victim, let an amicus be appointed to represent the victim. Post.
I think you know. Parliament. Officers of item. The other item fixes.
Yeah, Agarwal can be.
You know.
Yeah, Agarwal for that. Dr. Pierre. See, present. Dr. is looking after the list of the amicus. Dr. P. Agarwal can be.
P. Agarwal. She's good.
She seldom presents. He used to be there, man.
Return late, Dr. P. P. Agarwal be appointed as amicus to represent the victim of this case. The rest we will do the need. Rest we will do the need. Do you want any fixed date here or
My lord,
do you want
fixed
any
date, yes,
fixed
my lord, there is a bail application pending. Today I was moving the bail application because he is in jail for last 4 months. Seven years conviction.
One.
12 or 13 May, my lord.
15.
My lord.
15th of May. 15th.
And on that day, my bail application will consider. On that day, bail application will be considered.
Supposed to be. We may hear the bail application on that.
Yes.
Whether we have received the case record already?
Case record received, my.
Everything is ready then.
It is there.
We go for the hearing also otherwise. If it is ready, main head of litigation. Hard chance to fix. Says can the teacher has already been received. Okay, we'll see.
My lord, may I pray one thing, my lord? Item number 41, my lord, that is hearing matter. But in this matter, my lord, interim maintenance order was 4,000 for illegitimate child. In the meantime, 4,000 enhanced to 7,000 on 6/11/2025, madam. We already prepared the petition. In the meantime, we will file the matter, maybe come up after 2 weeks, madam. In the meantime, we will file, and in the motion stage, we will take the matter. We will take the matter.
Take the matter means? From where will you take the matter?
Earlier matter, my lord.
I'm not following you. Take the matter means?
My lord, in the motion stage, we will take this earlier matter along with the new matter, my lord. We will file the matter. Item 41. 40. Yes, my lord. Item 41, my lord.
Item 41.
41, my lord. In this matter, my lord. No.
41 was adjourned in the morning hours. You are for the petitioner?
Yes, ma'am. Maybe anybody, other petitioner. Other advocate is there.
You have not been informed?
Not informed me.
Oh. Oh, you
No,
must
no,
be
no,
informed.
no.
Repeatedly,
Okay, all
I
right.
asked the every advocate, then have you informed, have you informed? At least you can. Even after the order also it can be informed.
No,
But
no.
you are not being informed.
Not informed.
Oh.
All right, no problem, my lord. In the meantime, we will file the petition.
Yeah, obviously you can. And after filing it, try to bring your
try to
new
bring this,
application on the record.
Yes.
Okay. So that it can be tagged with